Moving toward your seats, we'll get going here in a sec. All right, welcome back. Good morning. Here we are at the third and final day of the summit. We had a great time last night out at the Desserts and Drinks event. A big thank you to the Real Edwards Conservation and Reclamation District for sponsoring that. Also, thank you to Glasscock Groundwater Conservation District for breakfast again this morning. Exhibitor bingo, last day to do that. I know some of the exhibitors haven't been always at their tables, and so if you visited 20 or more of our exhibitor tables, then it's fine. Okay, then you will be entered to win a $100 Visa gift card. We have 2 of those to give away. So encourage you to do that. You've got the break at 10 o'clock to do that as well. Couple quick announcements. If you do need to store your luggage, you can do that over at Charlie's Long Bar this morning, since I know checkout is before the end of the conference. I also want to take a moment and thank the Lone Star Groundwater Conservation District for sponsoring our speaker gifts. All of the great speakers we've had here this year are receiving a bottle of Dutchman wine, a local Texas winery. If you are a speaker and haven't picked that up yet, you can swing by the registration table to do that. I also want to thank our supporting sponsors, Advanced Groundwater Solutions, the Barton Springs Edwards Aquifer Conservation District, Brush Country GCD, Groundwater Consultants, Harris Galveston Subsidence District, Michelle Sutherland, Prairie Lands Groundwater Conservation District, RRG Professional Engineering, and the Trinity Glen Rose Groundwater Conservation District. So without further ado, I can't think of a better way to start the day than talking about EAA versus DAY. That decision is now 10 years old. In the wake of that decision, attorneys Greg Ellis and Russ Johnson had shared some of their perspectives on what that decision might mean in some commentary published in the Texas Water Journal, known as, it was a few pieces called A New Day. It's been 10 years. We thought it was a good time to look back and revisit really what did that decision mean. So we have asked Greg and Russ to return to the stage and give us a little fireside chat about really how DAY has played out, what we know, what we still don't know, and the like. Let's give them a warm welcome.
Okay, this is the Greg and Russ Pony Show. I'm not sure which one of us is the dog and which one's the pony. Usually starts with who's going to go first and which one of us will filibuster the other one. So this is going to be a unique thing. We're not doing individual presentations. We're going to go back and forth and try and make it more of a discussion this morning. That doesn't mean we're not going to filibuster. So for those of you who don't know, I was actually the first general manager of the Edwards Aquifer Authority, and I was basically the person who recommended to the board that the Day and McDaniel permit be denied. That resulted in some litigation and ultimately resulted in a Supreme Court decision in Edwards Aquifer Authority versus Day. A little bit of history about the permit itself. The Day and McDaniel Farm Ranch was very far south in Bexar County. They were very close to the bad water line. As a result, the well that they drilled essentially had been eaten up by the sulfur that was there, and so it became a free-flowing artesian well. Just pretty much flowed all the time. It flowed out of the well and into a drainage ditch, and from there it went into a soil and conservation built dam that formed a lake, which they used mostly for recreation. And then they would pump water out of that lake to irrigate most of the pasture land they had for their ranch. They did have 7 acres of land that they were able to pump the water directly from the well to irrigate that 7 acres. So when it all came through the contested case process, the SOA administrative law judge recommended that they get a permit not for the 750 acre feet that they had requested of 2 acre foot per acre for the 350 acres they had irrigated out of the lake, plus 50 acre feet more for that recreational pond. Instead, they got a permit for 14 acre feet. For some reason, they weren't happy with that, and they filed a lawsuit. The trial court ruled that the permit was correct and that the other constitutional claims that were being made by Day and McDaniel were not valid. They said that you don't get to make a takings claim because under the rule of capture, you don't have any claim to ownership of that groundwater. It's not a vested property right before you capture it. The act of capturing the water is when that property right vests. So that was appealed to the Fourth Court of Appeals, and the Fourth Court of Appeals held that they overruled the trial court. They said that the water in the lake was being put to a beneficial use, and therefore they should have gotten a permit for some portion of that. They said at least 150 acres. They didn't find evidence in the record of 300 acres. But they also denied all of their claims that were based on the Constitution. The Fourth Court then overruled the trial court, and that meant it was going to go to the Supreme Court. Both sides actually appealed to the Supreme Court because Day and McDaniel wanted to get their takings claim in, and EAA wanted to get the proper permit because they didn't think that they were entitled to the water that would flow into the lake. So the Supreme Court took up the case. It's one of the, I think, a fairly rare case in that they really went in depth, probably more in depth than they needed to answer the question, in laying out all of the ways groundwater conservation districts can regulate, the whole takings analysis, and ultimately reached the wrong conclusion. It's kind of, I say that laughingly because the truth is the Supreme Court doesn't make wrong decisions. They're the decider. Whatever they decide goes. So from that point forward, that vested property right in the groundwater prior to capture is the law. I want before I let Russ talk, I want to kind of go through just a real quick list of the decisions that were made and who won that decision. Edwards Aquifer Authority won on the following issues. The correct permit amount was the 14 acre feet because the water that flowed into the ditch, as soon as it crossed the banks of that ditch, it lost its character as groundwater and became state water. So the water that they pulled out of the lake was all essentially stolen from the state and not the property of Day and McDaniel. The regulation that allows some use of groundwater, the exempt uses of 25,000 gallons per day and the 14 acre foot permit, cannot represent a physical invasion of the property. So they said this isn't a physical invasion taking it all. The regulation is essential in the conservation and use of groundwater. Since 1904, the Supreme Court has been saying, legislature, you need to take care of this problem. We don't want the courts taking care of it. You need to have administrative law handle this rather than litigation. They then said SOA did not have authority to rule on constitutional issues, such as whether or not the EAA Act was constitutional. That's something that Day and McDaniel had argued they should have been able to put on their takings case at the SOA level. They did not have a right for its contested case hearing to be before the full board instead of SOA. That was another argument they made. Day's open courts claim, which is a constitutional claim, and complained about the ex parte communications allowed by the Administrative Procedures Act between the ALJ and the agency staff were all dismissed. EAA won those issues. The court said the substantial evidence rule does not deprive Day of the right to present evidence of his takings claim. It said EA's issuance of a conditional drilling permit was not arbitrary or capricious. It said the state has a legitimate interest in discouraging suits against districts. Therefore, 36.066G about attorney's fees was rationally related to that legitimate state interest and therefore does not violate Day's equal protection rights. Day won on the following issues. The trial court should have considered Day's takings claims because there's a vested property right in groundwater prior to capture. That's the only issue they won, and that was the big one. So from here, I'm going to turn it over to Russ and talk about some more of the history of I guess, the EAA and how we got here.
Thanks, Greg. And, we've done this. We've been on the podium together for, 20 years now. And I think it's helpful to kind of put this in perspective. First, I want to read you from a Baylor Law Review article published shortly after the decision. And interestingly, the author, a professor, starts the review with this sentence. In early 2012, a watershed Texas Supreme Court case, Edwards Aquifer Authority versus Day, turned Texas water law on its head. I'm here to argue that, in fact, it set it on its feet and and correctly set the parameters within which regulation of groundwater by groundwater conservation districts should occur. So I thought that was kind of an interesting little observation. I also brought the Austin American-Statesman front page from Tuesday morning. I woke up to come down here for the conference, and the headline was, "Less groundwater, more demand." So I felt like that was a signal that this is an important topic and worthy of consideration. So just by way of background, at the time I practiced law in San Antonio. My principal client was the city of San Antonio's water system, SAWS, and as a consequence, as their principal lawyer, I was involved in all the battles that led to the creation of the Edwards Aquifer Authority. And I want to give you just kind of a brief summary of what took place to lead to the passage of the act. But I like to say, in terms of the speakers this morning, I was there at the creation, actually pre-creation and inception. Greg was an observer and an active participant shortly thereafter, so he took over at birth. So that's kind of a summary of of the history, and I want to set it in context, because I would like to say right up front that I'm not sure that a similar piece of legislation would survive challenge today if passed for a variety of reasons. But understand that the problem was that San Antonio relied exclusively on the Edwards Aquifer for its municipal water supply. And it did so with the assurance of the case law that said, in essence, the producer of groundwater was not liable to others for the impact and potential adverse effects of their pumping. And most importantly, in the Clayton Williams case, Fort Stockton held that, in essence, the groundwater producer was not liable for drying up a spring, because that's what Clayton Williams had done in connection with his agricultural operations to Comanche Springs. So that led, frankly, and keep in mind that the spring flow from Comal and San Marcos Springs in times of low rainfall provides up to 70% of the base flow of the Guadalupe River. That is the discharge point, if you will, for Comal and San Marcos Springs. So in essence, you have the classic situation of downstream dependence on spring flow and groundwater production dependence on those that use the aquifer. And to make it more complicated, there were really three distinct interest groups involved in the Edwards Aquifer. To the west of San Antonio, there was a tremendous amount of irrigated agriculture supported by production from the Edwards Aquifer. And those farmers used virtually as much water, perhaps more, than the entire municipal community in San Antonio. So I, back in the day, used to say the aquifer's total recharge, if you will, its input, was dedicated to roughly 3 equal parties: the farmers to the west, the San Antonio, New Braunfels, and San Marcos municipal use and industrial use, and then the springs. And oddly enough, each of those groups used about a third of the average annual recharge. So to make a long story short, GBRA, the manager of the Guadalupe River, went on a jihad in the 1980s to correct what they felt was a threat to their river system, filed a bunch of actions, including an action to declare the Edwards as an underground river, but most importantly, filed a lawsuit against the state of Texas, basically alleging that the state had failed to address the impact of production on the springs. And the reason it was filed under the Endangered Species Act is because, of course, there are endangered species that reside at Comal and San Marcos. So that case was tried to Judge Lucius Bunton in Midland. Judge Bunton never met a state problem that his federal court couldn't solve. He was what we would call an activist judge. Ruled for the plaintiff and ordered, in essence, the state of Texas to either create a solution to the problem or suffer the court's remedy, which would have been primarily focused on protecting the springs under the Endangered Species Act. And to put it further in context, the models showed that in order to protect spring flow at Comal and San Marcos Springs during a repeat of the drought of record, the total production from the Edwards Aquifer had to be less than 100,000 acre feet. And at the time, we estimated it to be substantially in excess of 400 to 450,000 acre feet. So that framed the issue for the Texas legislature in 1993, which led to the passage of the Edwards Aquifer Act. And I think it's safe to say that the act was controversial when passed. I think it's also important to note that the minute it became effective, and by the way, it was passed in '93 for voting rights reasons. The federal government blocked the implementation of the act after its passage. So it wasn't until '95 that the legislature had a chance to kind of fix that problem. As a consequence, the act didn't become effective until 1996. When it did, I'm sorry, in 1995, I guess. 96. Summer of '96, immediately the Medina County Underground Water Conservation District challenged the constitutionality of the act and filed a lawsuit. And to make a long story short, in that lawsuit, the court didn't decide whether the groundwater right was a vested property right subject to constitutional protection, but assumed that, and then, in essence, found that the facial challenge, the pre-implementation challenge, did not have merit because it was possible in the court's mind that the act could be implemented without trampling constitutionally protected rights.
Just a quick note. In that Barshop case, Barshop was alphabetically the first director listed of the directors being sued by the Medina County Underground Water Conservation District. I filed a friend of the court brief, and in that brief I made the argument that there can't be a taking of private property, that the act cannot cause a taking of private property because the rule of capture itself precluded that. And I, again, made the argument that right doesn't vest, that property interest does not vest as a property right until the water is actually captured, and I got that straight from the rule of capture. And we argued about that question for the next 20 years.
So to make a long story short, Greg summarized the process of deciding whether Day and McDaniel were entitled to a permit. I think an important point that needs to be recognized is that groundwater loses its character under the Supreme Court's decision as groundwater when it's put in a watercourse. It then becomes the property of the state and is no longer subject to the ownership of the landowner. So with that, Greg, that kind of sets the stage for the decision. You want to cover briefly the decision? Or?
Well, they decided, of course, that there is a vested property right in situ prior to capture, but not in any particular amount, which, again, doesn't make any sense to me, because in order to have a vested right, it has to be measurable. They even say that in the opinion. There has to divest, you have to have a measurable, determinable amount. But then they go on to say we can't do that for groundwater because groundwater recharges and discharges. It comes out through springs. Lots of people are pumping it all. The rule of capture says everybody gets to pump as much as they want to unless there happens to be an administrative law overlay of a groundwater conservation district there to prevent that from happening. I think a couple of the important holdings, it's important to mention that first, of course, they said whether groundwater can be owned in place is an issue we've never decided. So all of those arguments I had with Russ for the years before that, I was right. They had never decided that question until this case. But we held long ago that oil and gas are owned in place, and we find no reason to treat groundwater differently. They then went on to talk about all the ways we have to treat groundwater differently than oil and gas, but that creates the problem of, do we follow all oil and gas law when we're dealing with groundwater? And the answer to that's going to be in some cases yes, and in some cases no. The cases that have already been decided, generally the answer has been yes, we're going to treat it the same as we do oil and gas. In many areas, another part of the opinion, in many areas of the state, and certainly in the Edwards Aquifer, demand exceeds supply. Regulation is essential to its conservation and use. So while holding that the regulators can be held liable if their regulations go too far, they also said that regulation was absolutely essential. This is one of my favorite quotes. Groundwater is different from oil and gas. Aquifers are often recharged by rainfall, drainage, or other surface water. The amount of groundwater beneath the surface may increase as well as decrease. Any volume associated with the surface is constantly changing. Groundwater's many beneficial uses for drinking, agriculture, industry, and recreation often do not involve the sale of the water. Its value is realized not only in the personal consumption through crops, products, and diversion. Groundwater may be used entirely on the land from which it's pumped, or it may be transported for use or sale elsewhere. Consequently, regulation that affords an owner a fair share of subsurface water must take into account factors other than the surface area. So, a direct statement, we shouldn't be following correlative rights, so where the amount of groundwater you can pump correlates directly to the amount of surface acreage you own. A landowner cannot be deprived of all beneficial use of the groundwater below his property merely because he did not use it during an historical period and because the supply is limited. So the court said every landowner is entitled to get access to their groundwater, but you have to be able to regulate it. And that regulation doesn't have to be based on the amount of land that they own. And it's vested, but not in any particular amount. That means we've had a huge number of questions that opened up, and a lot of them have yet to be decided. We have had several lawsuits that have occurred since then, of course, the most significant one being Bragg versus EAA. The Bragg pecan farms, they had two orchards. One was the Home Place Orchard in Medina County. The other was the Dehennis Orchard out near Dehennis. The Dehennis well wasn't drilled until after 1993. It was in that interim between when the act passed and when it took effect. A bill that was filed to change the dates to cover those wells drilled during that period was killed on the House floor by a point of order. So the dates never moved. So everybody who drilled a well between 93 and 96 was in the same position as the Braggs in that they didn't have historic use that they could use to claim that EAA permit. So the Dehanis Orchard was denied. You cannot get a permit for that. Statute said that. On the Home Place Orchard, they got the exact same permit every other irrigator got. They got 2 acre-foot per acre for every acre of land that had pecan trees on it. The problem is, and they were able to prove this up in their trial court later, pecan trees need 6 acre-foot per acre, not 2. So their investment-backed expectations, their investment in their property as pecan orchards, required a minimum of 6 acre-foot per acre. Now the Braggs in their lawsuit tried to argue the amount of water we're not allowed to pump is the measure of the damages. And Solace is currently paying $5,000 an acre foot for that water, so we want $5,000 an acre foot for every acre foot of water we cannot pump. The Fourth Court said that's not how you do the measure. They said the measurement there is based on the value of the property as a whole for its intended use based on your investment. So if you invested in pecan trees, you have a much better claim to that takings than someone who was growing corn or somebody that had a small business on that property and only needed a small amount of water. So while they flat out said you cannot deny someone access to their water, Bragg said the only way we're going to measure damages is based on your investment-backed expectations. So the first question I have is, what are the damages for someone who's never drilled a well? Russ?
You know, I love it when he throws those hard balls at me, particularly when he aims it right at the head. But the bottom line, and this is really the fundamental question that's still, I think, unanswered, is what about those folks that haven't invested in producing groundwater? Are they protected? And do they have a claim if that right is eliminated? And I would also say that the Supreme Court, if they had to look at it again today, might be less dismissive of the correlative rights concept of ownership or use, given the potential that the only claims that will be recognized are those that are based upon some investment-backed expectation. And I get it. I understand the jurisprudence with regard to regulatory takings. But as a practical matter, it's an ironic result that those that are protected are those that have used the resource, not conserved it, and those that are not protected, arguably, certainly in Greg's mind, are denied the benefit of their ownership of that groundwater potentially if they're told that they cannot produce it. So I think it sets the stage for, and I want to kind of follow up on where we are and what it means. There's been very little jurisprudence since Day on the takings issue. There have been some cases. Greg may cover one of them. But interestingly enough, in the Coyote Lake Ranch case decided by the Supreme Court, which I won't bore you with the details, but it was a battle between the city that owned the groundwater rights and wanted to produce that groundwater and the surface owner that wanted to develop that property, and the city's well field would have interfered with that intent. And the Supreme Court basically, despite its dismissal of oil and gas law as relevant to groundwater management, determined that the accommodation doctrine in oil and gas, which basically says while the mineral owner is the dominant estate, the surface owner has the right to continue, and damage caused by the operations should be considered. So bottom line is the Supreme Court adopted an oil and gas principle that protected the surface owner from the actions of the groundwater owner and producer. And interestingly enough, so the law has been well established that that's true in oil and gas for decades, maybe a century. It was the first time, of course, that the Supreme Court had addressed that question. And interestingly enough, ascribed dominant estate character to the groundwater estate, just like oil and gas. And so one of the questions that I always have is, well, which of these dominant estates is more dominant? What if you have a oil and gas owner who wants to use groundwater, and you've got the groundwater ownership in presumably either an independent party or the landowner, which is also a dominant estate that would be adversely affected. So which of those dominant estates prevails? I throw that back to you.
That's a great question, and I have to tell you, one of the open questions that we're going to have to answer eventually is where we have set a limit on how much can be produced per acre, for example, and there's an oil and gas operation there, and that oil and gas lease says we get to produce as much water as we need to be able to explore for and capture this oil and gas, and they're using all of the available supply. What does that leave left over for the owner? And the oil and gas, by the way, is 100% exempt from regulation by the Groundwater Conservation District. The mining operations, obviously, if you have to dewater a mine, there's no way that the district can say you can't pump that much water out because that makes the mine inoperable. Oil and gas operations are exempt from district regulation, and especially, well, the law says it's in terms of drilling, getting a drilling permit, but I don't know of a single district that tries to regulate the operation of a well for oil and gas operations, other than there are a few districts out there that do try to regulate oil and gas operations if that water is being used for fracking as opposed to rig supply for a drilling rig. So that is one of the main open questions, is which is the more dominant estate. And it's probably going to be a long time before we get an answer to that particular question, because I don't see a lot of conflict there. I do want to point out, very important case, right after the Day case came out, a group of ranchers came in and applied for permits from EAA. This was, the deadline for filing an application was December 30th, 1996. They filed their applications in 2012. Those applications were obviously denied. The statute prohibited those permits from being granted. They sued, also in federal court, and the federal court judge ruled that there was no equal protection problem, there was no due process problem, and their takings claim was too late. They said there's a 10-year statute of limitations on filing a takings claim. GG Ranch is the name of the case. They appealed that to the Fifth Circuit Court of Appeals. The best opinion I have ever read out of the Fifth Circuit, it's so good I actually memorized it. For the reasons stated by the district court, we affirm. That's the entire opinion. So that's what saved the Edwards Aquifer Authority. Had that case gone forward, had there been potential takings claims from all the people who were going to come in and apply for permits, that would have represented thousands and thousands of landowners who did not qualify for a permit but owned that land and owned that groundwater, but now they're too late to make that claim. So that's why there's never going to be another EAA, because no one's going to make that mistake again. No one's going to wait 10 years to file that lawsuit.
Let me jump in and hit some of the big questions, because I think that's why we're here, really. So I asked this question rhetorically. Is the MAG number, the Managed Available Groundwater number, a limit on total permits issued? And I would suggest that the answer has to be no. The problem is, and by the way, the MAG for, if you will, the preservation of spring flow in the Edwards Aquifer is way lower than the total permit amount. I think total permits are how much? 600, 700,000 acre feet?
In the Edwards?
Yes.
I think it's 587 or something like that.
587. Yeah. Even though the statute had established a limit of 450.
450, right.
So you have to ask the question, what happens when you get to the MAG? What is your groundwater district to do when it's
When production equals the model available groundwater number. That's the problem.
And that is a huge problem. So what do you do, Greg?
I have no idea. You can either, I mean, before a day, I told my clients, you can say we're going to stop issuing permits. We're done. I think the Supreme Court's going to look very badly at that decision. They've said you can't tell a owner they can't have access to their groundwater. The other option is grant the new permit as it comes in, give everybody else a haircut in order to make room for the new permittee, but that opens the potential for them suing you for takings. So more than likely, and I think we agree on this point, the MAG is going to change. The DFC is going to change to allow more production to occur, and that's just going to continue time after time so that the districts can avoid these lawsuits.
So I want to throw out a couple of other things that are, of interest and unanswered. Districts that regulate by spacing only run the risk of having to say no to a potential landowner who would otherwise be able to produce groundwater because the spacing rules of the district prevent them from drilling a well within a certain distance of an existing well. I throw that out as, what do you do then, Greg?
Well, and the other problem with that is right now they're not required to get notice of the original permit for the original well, and they don't, I think, have standing to challenge the drilling of that well. So where the spacing regulations allow me to drill a well on my property that eventually tells Russ he's not allowed to drill a well on his property, that definitely could be very problematic for districts.
So the other area of concern, I think, are those districts that regulate by use without reference to land ownership. And this also has some relevance to water utilities, particularly non-municipal water utilities, who obviously typically don't own a tremendous amount of property, but produce large quantities of water from a small piece of land. So what do you do? I mean, honestly, with this question of what's the impact?
And of course we have those lawsuits coming, I think, shortly based on the Vista Ridge pumping, where now in that case, Vista Ridge did buy a lot of water rights, but the impact of their pumping is going well beyond the properties where they purchased the water rights, in not only within that district, but outside the district into other counties. My recommendation to those utilities is they need to go start buying up water rights. I think that if you own a utility, while you might be able to make a legitimate claim for your historic use and the amount you have already invested in producing, when you start to grow beyond that, I strongly recommend you do so through the purchase of water rights from other people so that you're covered both ways.
So, the next phase, I think, of jurisprudence on regulation of groundwater in the context of takings is yet to come. Clearly the groundwater districts and their management seek to protect the groundwater resource through limits. So when those limits are reached, one of two things is going to happen. Either the limits are raised to accommodate new users, or some adjustment needs to be made between those historic users and the new user. And that's going to be a challenge for every groundwater district out there in avoiding takings claims. And that leads to the other question, and I think you identified it in the list you sent me, which is the domestic and livestock exemption provided for in Chapter 36 sufficient to avoid constitutional takings claim?
And that may be true for anything larger than 10 acres, because you're allowed at least one well per 10 acres, I think. I don't know if you got 50,000 acres, if that means that you can get 5,000 wells. But certainly if you have more than 10 acres, you're entitled to a domestic and livestock well up to 25,000 gallons per day. I think that's a capacity limitations. I think you think that means they can get to 28 acre feet per year. I don't know that it means they can pump the full 28 acre feet per year, but certainly that would apply to those exempt use wells. For anybody less than 10 acres, they have to come get a permit like everybody else. And they're going to have to prove up their beneficial use, and I think they're going to have to prove up, in some cases, no unreasonable offsite impacts. And if I've got a 65 by 100 foot lot in my suburban neighborhood, there's no way I can produce water from that well that's not going to have dramatic impacts to neighboring properties. And if every one of those lots drills a well, the impact on the aquifer is going to be absolutely devastating. And the impact on all the other wells there is going to be devastating. So yeah, that is a very, very tough question.
So, the other thing I think that we need to consider is where do we go from here in terms of takings claims and regulation. I do think we're going to see litigation in the future as mags are reached or permit limits are reached.
And because these are constitutional questions, it requires litigation. I don't think the legislature can address them statutorily.
So, we're running out of time, and I want to leave you with the bottom line. Groundwater conservation districts are going to have to walk a very fine line between regulation, protection of the resource, and the property rights of the regulated community. And it's a challenge. It's a major challenge that we don't have really jurisprudence to help answer how best to navigate that narrow channel between those two interests.
I'll leave you with this bottom line. As the Supreme Court recognized in Day, the only way you can protect your property rights in groundwater is if there's a groundwater conservation district telling your neighbor what they can and cannot do. And as all of the groundwater district managers here and board members here have already heard, landowners will tell you, I do not want you telling me what I can do on my property, but you better do something about that SOB over there because he's just being unreasonable. So that's the line. That's where we have to. Now, we had the Vizino case filed where a neighboring landowner tried to sue the district for granting a permit that allowed drainage from his property. And unfortunately, that settled. The insurance company wrote a check for that. And so we don't have an answer to that question. I thought that case might help give us an answer there. But it would have resulted, had the Vizinos won that lawsuit, that would have resulted in a bizarre situation where I can't sue the person pumping the water because of the rule of capture, but I can sue the district that gave him a permit and get my damages from the district. That simply cannot be the final result. If that's the case, there's no reason to have groundwater conservation districts. And while you zealously represented your client's interests, I have to point out that the $4.5 million verdict the Braggs won, 80% of that was paid by your client. So had your client taken the opposite position in Day, it might have saved him $4 million.
He loves to criticize. It's just inherent and I think it's also important to note that the Day case did settle as well. And what is interesting about that is that if you applied what I call the investment-backed expectation approach to a takings claim by Day, and you use the model of Bragg to measure damages, the irony is that by the time the Day case was decided, the value of the Day property had quadrupled, largely because of development in the area. So it was a challenge to make a damage claim on behalf of Day in the context of the measure of damages that the courts had outlined. Thankfully, it settled. I think it settled for a variety of reasons, not the least of which was that the court's decision.
Fatigue.
Pardon me?
Fatigue.
Fatigue. But the court had also indicated that, kind of in no uncertain terms, that Day had been damaged by the potential loss of the right to produce the groundwater. So interesting questions still remain. I think we set groundwater law on its feet. We didn't turn it on its head. And by the way, it was a routine topic on groundwater law seminars, this question of whether the right was vested. Now that we know that it's vested, we have a whole myriad of new questions that need to be answered.
It's kind of like hydrogeologic studies. The only conclusion I've ever read in the hydrogeologic study is that we have to have another study. Same thing with litigation. The only thing that they settled is we're going to have a lot more litigation on this. And I want to leave my favorite question from all of this. We're trying to push very hard. We've seen a lot of legislative policy pushing us toward aquifer storage and recovery. Is groundwater stored in an aquifer subject to the rule of capture?
Yes, sadly. But
Because if it's not, then it represents a super vested property right.
indeed. So we have a lot of questions unanswered. Sorry we couldn't answer them for you, and thanks.
I don't think we have time for questions, but yeah, Russ and I do routinely filibuster long enough to get the questions out of the way.
That was great. Thank you, guys. That was a lively discussion, and it's always fun to start the day with a dog and pony show. So thanks for that. So just as aquifers are diverse, so are the issues that different districts face. Our next panel is going to be exploring some of the issues that districts are experiencing relating to groundwater quality. We think a lot about and talk a lot about, is Texas going to have enough water in the future? But really equally important to that quantity question is the quality question. And we're going to be hearing a little bit about that today. I am pleased to introduce our moderator, Diana Thomas. She is the general manager of the Sterling County and Erie County Groundwater Conservation Districts, and also a member of TAG's executive committee. I'm going to invite our next panel to the stage and allow our moderator to introduce her panelists. Let's give them a warm welcome.
Good morning. So our first panel here this morning is issues in water quality, as Leah said, and we're going to discuss a variety of water quality threats to groundwater resources, some common themes, and talk about some case studies here with our GCD partners today. We have Vince Kloss, who is a hydrogeologist with Allen R. Standen, LLC. We've got Mark Freeberg, who is the Executive Director of External and Regulatory Affairs with the Edwards Aquifer Authority. And we've got Janet Guthrie, the General Manager of the Hemphill County Underground Water Conservation District. You guys can read their full bios in your paper pamphlets or on the app, which I hope you guys are fully versed in everything the app has to offer by now. So this morning, we're just going to go ahead and jump right on into it. And Vince, will have you start us out with kind of a high-level overview with your experience working all across the state of Texas, how complex these issues really are.
Okay, I think that's quite a good place to start this morning. And I would like to start off by thanking TAG for inviting me to be here today. This has been a great conference so far, and I'm thrilled to be part of the discussion here this morning. And Diana, thank you for organizing and now moderating this panel for us here today. In regards to your first question here about water quality issues and the complexities of those issues, I believe it really begins with, one, knowing your geology, and then two, being able to identify what can make those geologies susceptible to contamination or water quality issues. where you have a karst or alluvial aquifer system at land surface, your water quality risk factors are going to be very different than somewhere out in the Gulf Coast or the middle of the Permian Basin, where you may have several hundred feet of shale and other impermeable layers protecting your aquifers from activities at and or near land surface. Now, this also includes not just understanding the geology of your aquifers, but also those surrounding geologic units that in some instances may provide protection and offer a little sigh of relief, while in other instances may be direct conduits or pathways for contamination or degradation of water quality. And unfortunately, it's the latter here that usually leads to undetected harm, as infrequent such as arsenic or radionuclides can become mobilized through some of these pathways. Now, once you have an understanding of your geology, you can then begin to better understand what your potential risk factors are for water quality issues. Across the state of Texas, our geology is quite unique, so there isn't one exact blueprint on how to go about doing this. For some, this is going to include being aware of former sulfur, lignite, or uranium mining operations, orphaned and abandoned oil and gas wells, or even defunct or dilapidated chemical and industrial sites. At the end of the day, there isn't a water well or aquifer that's immune from these water quality issues. It's up to us to be proactive in our approaches to ensure that these issues don't arise in the first place. Now, one thing to keep in mind here is that once the water quality issue has been detected or discovered, the damage has been done at that point, and then the focus then becomes mitigation, which in many cases just simply means now monitoring a now undesirable portion of our aquifer systems.
And so, Janet, in a more agricultural and rural area, what are some of these complexities that you're having to deal with on top of all the aquifer complexities that Vince just identified?
Okay. The Hemphill County Groundwater District is located in the Texas Panhandle on the eastern side. We are a single county groundwater district that is in a rural agriculture and oil and gas environment. And when the district was first established, the water quality was a big question for the constituents who voted in favor of establishing a district. And they wanted to know what we would do to preserve the 15 million acre feet that are in storage and prevent potential contamination. And so, under well advisement of our consultant, the first step he established was to identify the potential risk, and that was going to be agriculture and oil and gas as potential sources of contaminants. And so, always a good place to start is with the basics, right? So we established our first program, which was a basic mineral analysis. And that included field testing as well as in-house testing in our lab. We are a small lab, small user, so the regulatory burden was not burdensome. And the testing is very simple and it's affordable. So we monitor for TDS, pH, conductivity, and then in the lab, those are done in the field, but in the lab we look at nitrates, iron, sulfates, fluoride, total alkalinity, and total hardness. Our monitoring wells are spatially distributed across the groundwater district. Some of the sources supply come from domestic, livestock, irrigation, and we were trying to move away from any non-used water well because we really want to purge sample to preserve the quality, integrity of that sample is truly reflective of what's in the aquifer.
And so now that you've been operating, getting this baseline data, has it become helpful in any issues or instances there at your district?
Absolutely. It's really helped distinguish the potential that a domestic well is truly going to encounter. And when we have had a higher elevated concern or contaminant that shows up, it's helped us to learn to understand what a basic mineral analysis will detect and what it will not detect.
And then some of the issues talked about earlier in the summit with new landowners. I don't know how often you guys have land changing
We do.
ownership.
We do.
But do you ever have these new landowners come in and say, oh, I think I have this problem. What can you help me with? And you say, well, step right over here.
Yes, I have one of those when I get home tomorrow. Yes. But, with the domestic, you go through a series of questions. What are the symptoms that you're experiencing? And it helps you guide where you want to go. We just do a full basic profile workup initially. One, because it's quick, it's easy, and it's free to them. And then, of course, like yesterday, they were advised, please stop drinking the water till I get back home. And then we'll test it and we'll see. And so it certainly helps identify what the level of concern perhaps should be. And that's just with a few simple questions and having a conversation with someone who has concerns.
And so, Mark, in a more urban and suburban area, what do some of those complexities look like for you guys at the Edwards Aquifer Authority?
Well, I think, as Vince said, our problem starts with the karst nature of the Edwards. We have a staff member that likes to say, during a flood, the Edwards is really good at filtering out cars or refrigerators, but it doesn't filter out much else. So we have to be cognizant of the sensitive nature of the recharge zone, and we also deal with the exploding population and changes in land use in different types of industry or different types of practices that have the potential to create a contamination of the Edwards. And we're fortunate enough to have an extremely competent technical staff that does constant water quality sampling. And while we see contaminants at low levels throughout the Edwards, we still feel the Edwards is an extremely clean aquifer, and we hope to keep it that way with the regulatory powers that we do have and partnership with the different landowners.
And with that change, do you ever feel like things are getting more complex, or is it just a new facet to the same complex issue?
I think it's a new facet to the same complex issue, but at least we have the ability to recognize the types of impacts that can come with those different changes. And so that's not to say that older land uses don't have potential for problems. Agricultural practices have potential for problems, but the new industry that's coming in and the explosion of residential areas create new problems and new opportunities for us to engage with our regulated community.
And I think it was said yesterday too by someone that the only thing you should expect is that things will change. But despite all of these changing aspects and complexities in water quality issues, Vince, you have actually picked up on some commonalities and some common themes, especially when it comes to groundwater districts and their responses. Will you share some of those with us?
I think when a water quality issue or problem first arises, the common theme there is usually panic, and then that's usually followed by an overreaction. And that's because water quality issues, it's just one of those things that's only better understood with time or after a problem does arise. Now, one thing that I do see a lot of GCD doing is going out and being proactive in regards to collecting baseline or background data. Now, that's a great first step. There's a big difference from collecting water quality samples and then going and entering that information in an Excel spreadsheet or a database management system to actually using that information to proactively identify areas of concern. So what's good practice here is to actually take that baseline and background data set that you have and to revisit some of those same wells every 2 or 3 years. And once you do that, you can then start to look for trends or outliers that may be emerging in your data set. And this is something that I think a lot of districts and others out there intend to do. It's just one of those things on a to-do list that never quite happens. But in terms of being proactive in our strategies, it's one of the prime ways to protect these issues from arising in the first place. Now, as you're reviewing data, looking for outliers and looking for trends that may be emerging, things such as higher TDS or higher sulfates from one year to the next, those tell a story, and then it's up to us to figure out what that story is that we're being told. Is this story a story of an improperly nearby plugged well that's leading to a water quality issue within the aquifer, or does this have to do with something that's dual completed across a formation where it shouldn't be? So once we have these outliers or trends that we've identified, we're actually being proactive in our approaches at that point in time. And I can think of one example in particular where we had an area with about 30 water wells, really good water quality. We're talking 300, 400 TDS water. And then there was this handful of about 5 or 6 wells right there in the middle of all these where TDS was over 1,000. We're looking at 1,100, 1,200 milligrams per liter. Had us scratching our head. Well, we took a step back. We looked at the data. We started analyzing what made these 7 wells in this area so special. Started looking at well depths, well completion. One thing that popped out to us right away is these were all the same driller. And so from that point in time, we realized, okay, this is a driller problem. Now, what's making this specific driller an issue here? Or what's providing an issue for this driller? And we realized that everyone else in the area was screening 40, 60 feet. This driller was screening 80 feet. So by analyzing this data and looking for these outliers, we were able to then work with this driller to help him better complete his wells moving forward. So that's just one example of how we were able to be proactive in actually using some of this data to solve an issue.
And Janet, your district saw an issue coming up down the road, and you guys took a great proactive stance on our water quality issue. If you'd share that with us.
Sure, be happy to. Hemphill County's blessed with oil and gas production, and when the Granite Wash Formation took off with development and new technologies for fracking, so did the level of concern for the impact of that to the freshwater quality. And so the chairman of our board worked with an operator of a new saltwater disposal well that was going to go in next to him, and he said, I want you to negotiate an agreement with them for monitoring of the water quality around this saltwater disposal well. And he said, you have any questions? And I said, yes. What's a saltwater disposal well? So that led to the quest of opening up the communications with the operators within the district and with the Railroad Commission. And we were very blessed that they were, one, concerned they were setting a precedence, and we said, yes, you are. But then, two, what would actually be the ins and the outs of this program? So that program we call our Point Source Monitoring Program, and that's where we are monitoring the aquifer for changes in specific contaminants that might be related to the oil and gas. Now, as Vince said, it's, you can explore and try to do some background work, but should something show up, it's not going to be our jurisdiction to remediate it or mandate the restoration. That's going to be dependent on the source of that. So, but the operators agreed to what has been, the protest has never been modified, but the agreement has been modified over the years, and now they have agreed to pay for, at an accredited lab within 1 mile radius of the disposal well, 4 water quality samples, and they'll do that annually. We've only had one operator that decided, based on the results of those tests, there were very low levels of hits in the BTEX analysis that was done, but they decided not to go forward. It triggered the research of why is that there and why is it all around there, and they decided not to go forward in that location with the disposal well. The industry was also backing off a little bit, but they got to use that kind of as an excuse. But it's given us a great deal of information and understanding of what we have found and what we haven't found. It certainly keeps us communicating annually with the operators as to, if you're a new operator in Hemphill County, here's the established expectation of you as an operator. And then there have been instances because of this where the company would reach out and say, well, you go get samples for landowner A over here, he's just certainly contaminated his groundwater. And I'm like, okay, fine, we'll do it, but it's not in the program. So our numbers are somewhere between 180 and 200. I should have looked at that specifically before I left. but it's a good number for annually for us to do. And it did lead to the district dedicating a full-time position to water level and water quality programs in the district. Whenever we complete that analysis, the water quality report is submitted to the operator of the disposal well and all of the owners of the water wells within that designated monitoring site.
And so this testing program not only happens before the disposal goes in, but is a continual throughout the life of that disposal?
Yes, that's correct. They've agreed to do it throughout the life of the disposal. So if they don't want to do the testing, we've had several that get their permit and then they decide not to go forward. They still get the test. And so it provides a benchmark, which we really encourage that you do, is establish the benchmark before it happens. And when we've had instances where these landowners were contacted and said, oh, we're sorry, we had a pressure control issue. You probably don't know anything about your groundwater quality. They said, oh, but we do. And the operator immediately moved into the appropriate actions to take care of that incident. In the instances where we didn't have benchmark information in that area, it was more of a difficult initial discussion. But most recently, the operators may change, but fortunately, some of the employees don't change. And so they became familiar with it, and they're like, okay, this is what I really don't like about this now. You guys picked the wells, we'll just pay for it. And so it has become even easier to administer and to oversee. The landowners like it. Unfortunately, they've kind of began to assume that it's going to happen, but sometimes we miss the notice that this is happening, and we may not reach out to them in time to say, hey, can we work this out? But they have agreed to do it. It started off as a 5-year interval test, and now it has moved to an annual test. And we're very satisfied and happy with that.
And in general, what has industry response been? Has it been pretty much the same throughout the entirety of this program, or do you have more acceptance of it as time goes on?
We have more acceptance as time goes on. A lot of times the operators, if they've been established and they've encountered this before, they'll contact us before they've even filed their application to the Railroad Commission, and we'll already have everything packaged up and ready to go and waiting on them to get their permit. So they have become proactive. Our first operator, they said, so are we going to do this with everyone? And we're like, yeah, we're thinking so, yeah. And so they actually incorporated it as a company policy, and they operate in multiple states, Texas and Oklahoma, and they decided that they're going to do that before they do any disposal wells.
And so, Mark, in our discussions leading up to this, it seems like the Edwards Aquifer Authority is constantly having to look forward and look for these water quality problems that may be coming down the road. What are some programs that you guys have put into place?
Well, I think the theme of commonality came up a lot yesterday with the discussion on abandoned wells. And so we've been struggling with that issue as well. We currently have over 200 abandoned wells identified in our jurisdictional region. And I don't want to suggest that we have our arms around the problem by any stretch of the imagination, but what we're trying to accomplish through our abandoned well program is to compartmentalize chunks of abandoned wells that we can try to address. And so what we've tried to accomplish over the last few years is to create a process where we use a combination of GIS information and on-the-ground information to rank the wells that we've identified. And I think Representative King made a good point yesterday when he talked about a deteriorated well. Just because these wells are abandoned in our books doesn't necessarily mean that they're deteriorated. So when we rank them, we look at risk factors, and we have what we call our top 20. These are the top 20 wells that we see as the highest risk to the aquifer. And we can re-rank those based on the ease of plugging those wells or the ease of addressing those wells and the costs that are associated with that. But that at least gives us the ability to take address those wells in chunks. We can make determinations on landowner resources or well owner resources, and if they have the financial ability to take care of that well, or if they need to have assistance, and use that information to try to leverage situations where we can get those water quality threats addressed as quickly as we can.
And so with the abandoned well discussion that has happened on previous days, do you find that you have new landowners that come in with the sale of property and say, I tripped over this hole I didn't know about when I bought it? Or how has the change in ownership affected that?
The change in ownership has been a problem and a solution for a lot of our abandoned well problems, or identification of abandoned wells. I think we're coming a long way with the real estate community, and that a well on a property isn't necessarily a benefit. It can be a liability. Openness and disclosure of wells on a property, I think, is growing and becoming more relevant to a new landowner. But when those change of when that property changes hands, it gives us an opportunity. Part of our program is that when we identify abandoned well, we file a notice of abandoned well in the county deed records. And it's not a lien, it's just information sharing. And that helps us tremendously, especially in the last couple of years when property was changing hands quickly. It's hard to close when there is a notice that there is this potential liability on the property. And we've used that process to leverage the closure of a lot of wells during that property transition. And so that's been very helpful to us. We also have landowners who, because of the attention that abandoned wells have gotten across the state, that do come to us and say, what do I need to do if I buy this property? And us being able to get into the process early and keep everybody on the same page, so to speak, as to what responsibilities there are. And the state law makes it clear that the responsibility of the well is the well owner. And we're here to facilitate them coming into compliance and protecting the aquifer in the best way that they can. They can put the well back into service, they can cap it if it's not deteriorated, or we can help them get that well plugged.
And what are some other ways that you find these abandoned wells?
So it's interesting. Over the past 10 years or so, we've been doing sweeps across our region. We started in Hayes County and have moved. We're currently in Bexar County, and we just try to look at, satellite imagery helps. If there are subdivisions that don't have a water supply, a public water supply, that's helpful. It's also helpful just driving around, and our staff will notice a windmill somewhere, and so we engage in some exploring on those properties through records with Water Development Board, historical wells. We try to find them and we try to identify them. Sometimes those wells don't exist anymore. They've been covered up either through development or other activities that have happened over time. But the records that we found do assist us in finding those wells, even if they've been covered up. We have found some that have been paved over that we've been able to remedy by opening up that pavement and getting them plugged.
And so a lot of these case studies that we've talked about so far have been pretty successful programs from inception, with maybe a few changes once the corporate lawyers got a hold of it. But what happens when a groundwater conservation district has a monitoring program and sometime down the line they kind of discover that it's not quite meeting the goals that it was intended for? Vince, do you have any stories on that?
Yeah, I think a good place to visit here would actually be with the Middle Pecos Groundwater Conservation District. For anyone that's unaware, they're out in West Texas, right in the heart of the middle of the Permian Basin, second largest county in Texas, and dealing with quite a few issues that pertain to legacy oil and gas activities out there. And most notably, Beamer Lake, which is about 65 acres now. It's a lake that's formed from free-flowing well waters from the #1 Sloan Blair oil and gas exploration well. Now, early on, Beamer Lake was just viewed as an oddity. It was just one of those things that people talked about in the community out there, and it was part of what was believed to be just about 10 free-flowing wells in the area. Early on, the district strategy here was to sample these wells, collect that information, and just get a better understanding of what was going on with these flowing well waters. Some of those early samples came back with pretty high TDS waters. Several of those wells came back with over 10,000 milligrams per liter, also very high sulfates, chlorides coming out of that water. And then the number one Sloan Blair, which corresponds to the Beamer Lake well, those early samples showed that it was over 60,000 TDS on some of those early samples at that point in time. So early on, what the district thought was just going to be a simple sampling exercise to just better understand water quality, quickly evolved with this new data in hand. And then there was an emphasis that was then placed on better understanding the impact of these flowing wells on the aquifers in the area. Since some of this early work, there have been around 30 new additional flowing well sites that have been discovered, with nearly all of these being tied back to oil and gas exploration wells. There's at least 5 areas of subsidence that have been discovered from these flowing well sites now, with the subsidence occurring because we've had deterioration of surface casing, which has then led to dissolution of the salt beds, and also what is now believed to include portions of the Rustler Aquifer. There's also new testing earlier this year that shed some light on the deadly levels of H2S gases that are being emitted through some of these wells. And that's also in addition to radionuclides coming out at rates up to 10 times higher than drinking water standards there. So there's a couple things going on here, but the biggest issue and biggest concern for the Groundwater Conservation District is that all these wells are flowing across about a 20,000 acre area onto the Pecos Valley Aquifer. Pecos Valley Aquifer is an unconsolidated alluvial aquifer system. It receives recharge through seepage, and that's where all these flowing wells are flowing right now. Now, the other thing here at hand is all of these wells are located about 1 to 4 miles from the Pecos River, which receives its base flows from the Pecos Valley Aquifer and is a direct tributary to Lake Amistad and the Rio Grande River to the south. So what started here as a simple sampling exercise for the Groundwater District at the time quickly evolved as new data came in, and it's continuing to evolve. We develop a strategy in terms of how to go about either sampling the groundwater or understanding a specific problem, and then new data comes to light, new issues arise. Right now, the current focus for the district is better understanding and quantifying the impacts on the Pecos Valley Aquifer. And also, we're looking at some strategies to look at water chemistry data to predict where we may have subsidence occurring in the near future. The chlorides in the groundwater seem to be a leading indicator. As those chlorides increase, we usually see subsidence occur afterwards. So really using that data to figure out some creative strategies to better understand the situation has been some more of those recent strategies. Now, early on when the district first sampled these wells, I don't think they ever anticipated going down this path that they're on now. But as the district serves to protect the aquifers of Pecos County, this is part of the job for them until someone else steps up to the plate.
And not only was it a significant pivot, I think, with the water quality, but it's my understanding with Ty's testimony before the House Natural is they actually are having equipment problems too with the sampling, that the water quality is actually eating some of their sampling equipment, and they're having to replace that, which was pretty shocking, I thought.
That's correct. It's very corrosive water. We've cambered some of these holes. There's no surface casing to be found anymore at this point in time. So that just speaks to just how nasty some of these flowing fluids are coming to land surface out there.
And so, Mark, what about the Edwards Aquifer Authority and any programs where you guys have had to pivot and make an adaptation to meet these intended goals?
Yeah, we have, the biggest one that I think we've had a pivot on is fires on the recharge zone. And I don't know if people in this room remember there was a large mulch fire in San Antonio years ago that created some air quality issues and some water quality issues. But shortly after that incident, there was some legislation passed that gave TCQ some additional regulatory powers over places that store mulch. But the bill also told the Edwards that we needed to do rulemaking on the control of fires on the recharge zone. And we didn't really know what to do with that. We don't have firefighting expertise on our staff. We did the best we could, and we created a regulatory program that essentially required different types of secondary containment in facilities on the recharge zone that had what we considered to be regulated substances within them. And it was an extremely cumbersome program to implement because it required re-engineering of structures. It required a lot of fairly burdensome requirements on a property owner that would be in place to protect in a catastrophic event. And I cannot tell you how many complimentary phone calls and well wishes from engineers and environmental consultants that I got over that program and how to come into compliance with that program. And after a while, it became clear that we were doing more to regulate than we were actually making a positive impact to water quality protection. So we pivoted. Our board of directors adjusted those rules, and we took advantage of an opportunity with the San Antonio's Edwards Aquifer Protection Program. The tax-based funding that they have to get conservation easements. In the last ballot initiative, there was a set-aside of a certain amount of money for water quality protection, and we partnered with Texas A&M University and got a grant for what we call our first responder program. And we adjusted our rules to be more information sharing. We require facilities that have these types of substances to give us information about the facility, what they store, and a map of flows, how water would flow around the facility, where things are stored, and where structural best management practices for stormwater are located. And we've created a information sharing system with City San Antonio Fire. And so to start, if a first responder arrives on the recharge zone at an incident, they get a notice on their truck that says, you're on the Edwards Aquifer recharge zone, this is a sensitive area. And that's where we started. Through the partnership with Texas A&M, a curriculum has been created whereby firefighters can get trained on karst, on how to identify karst. What does that mean? And why is it sensitive? And then we come in the back end and we've taken all of this information that we require the regulated facilities to give us, and we've mapped it through GIS. We've put those pathways, those flowways on it. We give a list of what's stored in the facility, and we identify where these water quality basins are. So a first responder could close those basins to capture water. It is important that we make it clear that we're not trying to get in the way of a firefighter. Their first, responsibility is human life and safety. So once they've addressed that, we hope that we've provided them with the tools to make decisions in the field that could protect against a negative impact to the aquifer. Recently, it wasn't in Texas, but I think it's a testament of how this program could be used positively. There was a fire at a Home Depot in San Jose, California, and it was a fire that came about quickly and completely took the Home Depot down. There was nothing left. And we asked for the incident report from the California Water Board, and we got it. Essentially, the first responders came, and they put about 600,000 gallons of water on the Home Depot over about an 8-hour period. So about 2 acre-feet of water over an 8-hour period. And that water flowed from that property. Of course, some of it boiled and evaporated, but they estimate that about 250,000 gallons was captured on site because they have some best management practices in place for firefighting water. And the remaining, they estimate 300,000 went into a creek, which went into the Guadalupe River, different Guadalupe River, that it would ultimately go out to San Francisco Bay, and they had quite a bit of monitoring of the water quality in that creek and in the river. We don't have anything like that in place, but now that we have this partnership where we can share this type of information, firefighters can make a decision. They can shut down some of those water quality capture basins. They can put different absorbent booms down. We can be cognizant of if this water leaves that property, especially on the recharge zone, it's not going to go into a surface water creek. It's going to go into the aquifer. And it's going to be much harder for us to monitor that water quality. And once it gets in, it moves quickly. And so we hope that the investments that we've made into this program sets ourselves up for better protection of water quality than our previous regulatory program. And so far, so good. The training should be starting soon, whether it's this fall or going into next year. We've got the GIS system in place. We're actively sharing it with the fire department. We've got a secure portal where we can update that information as new facilities come onto the recharge zone, or if a business changes, we have the ability to do that pretty quickly so that everybody knows what's going on. And we're hoping that this can also be used for some pre-planning. from the fire department when they look at, what they think they should do if an incident was to occur on the recharge zone.
I liked your overall assessment that you gave, and going from requiring a containment zone around every pallet of whiteout, you then pivoted to look at, okay, what are we trying to prevent this worst case Home Depot fire? And instead of going heavy on the one side, you're actually supporting.
Really changed, and it's going to set you back and make it far more difficult and timely to try to understand what the story is of why. So get started early.
And just one thing that, listening to us speak today, just how different everyone's problems are, how different everyone's concerns are, and the responses to those problems and concerns. And we're a big state, and I think the three of us up here just told a pretty good story of just how different that state can be.
Any questions from the audience, I think?
Does anyone have any questions? One back there. If you wouldn't mind going to the mic so the folks on live stream can hear it.
Quick question. Heard a lot about ground reservoir interactions and sort of upcoming interest in that. And a lot of people are talking about quantity exchange. Are there any thoughts on the quality aspect of it? Thank you.
I think he's asking about quality aspects of groundwater, surface water interactions and how that, there's been a lot of conversation about ownership and base flows and all that kind of stuff, but what about quality in that conversation? Did I get that right?
I was just going to say, our water quality sampling looks at everything that happens with our aquifer, whether it's a surface stream input, a well on our recharge zone, a well in our artisanal zone, or our spring. So as we learn more, we hope to better understand source tracking and those types of impacts, which I don't know where that leads, but it's information that we feel is important to have.
For us, we work with the Red River Water Authority. They have the jurisdictional authority and do study the rivers and water quality. And so we communicate with them and get to know and participate in their studies.
And I did have one question come in on the app. Do districts have the tools they need to address these water quality issues that you're facing?
I think funding's always helpful, and I know there's a lot of irony coming from one of the more well-funded districts, but we still struggle with how to address some of these problems, and I think as much help as districts can get, and where there can be statutory authority, that's always helpful.
I agree with that, and for us who's not as well funded and have that mechanism available, but understanding who the people are that's going to share that same interest, that would care. And it might surprise you that for us it's the oil and gas industry, but those employees, they live there, and so they're drinking some of that water too, and their children go to school there. And so they do share that same common interest and value. And so just reach out and talk to people, find out what other people are doing and go, that's interesting, but is it going to be relevant for us? And I think that's where TAG does an excellent job in this platform. Congratulations, Leah, you've done an excellent job. It helps bring that information available to you, but it's up to you to seek it and find those partnerships and those relationships that are going to benefit everyone mutually who shares in this interest.
I just want to pick up on a point you made there is piggyback off of others' ideas. Some of these strategies take a long time to develop, and if you know of someone else that's had a similar problem and has already had to go through this, lean on them for their help and their advice, and that's something that at the end of the day will save time. It will make things easier for you, and if you are a less funded district or have some obstacles there, being able to really, use a blueprint that's already been out there and provided to you.
Wonderful. Thank you guys so much. That was great. I promise I didn't ask Janet to give that promotional plug for us, but definitely appreciate it. Thank you. Thanks for that great panel, guys. It was really interesting and instructive to hear what different districts are doing. So before we move into our last coffee and networking break, we do want to provide you all with some information about a resource that we do have available. So I guess maybe we're continuing on the plugging tag and what we do. I'm excited to introduce our next speaker, who you all I sure know by now, Tag Zone Programs and Operations Manager Julia Stanford. She's going to talk about our new GCD Index Map Viewer.
Looks like we're getting my presentation up, right? There we go. Okay, good. Do I have a clicker? Okay. All right, so thank you so much. I'm thrilled to have this opportunity to come talk to y'all about a project that's been very near and dear to my heart. And as Leah mentioned, it's a very valuable resource that TAG has. So I'll just get into it. So the concept of the GCD index was conceived before me and Leah were around. Some of you old TAG members, or sorry, seasoned TAG members may have been a part of these discussions. So the concept was to have this visual representation of the TAG GCD database, of all the information that we have about the GCDs. So the first iteration of it was launched in 2014. We had some sponsor help from the Dixon Water Foundation, as well as the district sponsors, Barton Springs, Central Texas, Clearwater, Hemphill County, Lone Star, Middle Pecos, Sandyland, and Upper Trinity. Those guys all helped fund this original effort. So we had contracted with a local web development company, I believe, and this is the original version, which I'm sure if you're a TAG member, you've seen this many times. So it got the job done for a while. It has kind of awkward navigation. You have to click on a GMA first, which is great if you're in the groundwater world and you know exactly what GMA you're looking for. And there were only so many parameters you could choose from. Those are listed on the right side of the screenshot I have here. And so there was just only so much it could do. The worst thing, I'll get back to the worst thing. So there was only a single district view. You could just scroll down and you had to look through every single parameter for a single district. There was no way to easily compare them unless you were taking really good notes. You couldn't export the data, and in my opinion, the worst thing that gave me a lot of heartburn is that we couldn't update it. So someone would call and say, hey, this GCD index has something from a few years ago. I said, wow. Sorry to hear that. So we didn't have a relationship with the developer still. They stopped doing this kind of work. So we just had this thing on our website. So we knew we wanted something new. So we put out an RFP, and our friends at Half Associates, who I'm sure many of you have met outside there in our exhibit hall, they submitted a proposal and they said, all right, we know how to help you. We can do this. So we partnered with them to create this new GCD index. As you see it today, it launched earlier this summer in May, kind of in conjunction with our last business meeting. So right now, this is a screenshot of what it looks like. You can click around to find your GCD. You can see an overview of the districts. You can research how other districts work, which I think is a really valuable tool. And you can filter or sort by a lot of different parameters. We only had a few parameters that you could really sort by last time. Now it's more comprehensive. So I will walk through a couple of those just really quickly. So first of all, if you want to find the GCD index, you'll find it on our website, texasgroundwater.org. You can click on the Find Your District icon, which is circled on the bottom, or you can go up to Resources. I've also circled News and Events, where you can sign up for our newsletter if you would like. Just have to give myself a plug. So this is a screenshot of the GCD index as it is now. You can click around to just look at the different districts, or you can use this this search box to type in an address if you want to know what district you're in, or if you're looking to, I get a lot of calls, I'm looking to buy land, is it in a GCD? This can help you out. You can toggle layers on and off. It's got, the GCDs, the GMAs, Texas counties. There's even the geological atlas. I'll say when you click that one on, it takes a while to load, so make sure you're prepared for that. You also have the print function, which is something that I didn't even know we were getting. And when the guys at HAF showed me, I was like, okay, that's pretty cool. You can click that and print the current map view. So if you have like one GCD or certain plots selected, it'll print exactly what you're looking at in a really nice little format. You can also, if you forget all of this, there's a user guide button at the top, which will show you how to use all these features. It's pretty handy. So once you click on a district in the map, in the actual map viewer part, you will see this little pop-up box. So I've clicked on Sandyland UWCD here, and you can just kind of scroll through. You'll see contact information and all the other details in the GCD index. So that's a good way if you just really want to click around and explore a little bit. If you want to, I circled it there. If you want to take a deeper dive, you can scroll down to this searchable table, which is really, I think, where this version of the GCD index packs a punch. You can do a search, which is cool. So say you were here at the Groundwater Summit and you met a GCD manager. His name was David, and that's all you know. You can search for David and all of our Davids will pop up. Or you talked to someone in the Ogallala and you want to see all the GCDs that manage in the Ogallala, that'll pop up. So that's just like a straight up text search box. We also have, if you click on the text at the top of a column, that'll sort it ascending or descending. So that's good if you're looking to see, who has the highest or lowest tax rate, stuff like that. And then you can also click the little filter button. So you might be looking for all the districts that are in GMA 9. You can select that, click only GMA 9, and it'll show those. And then the coolest thing, I keep saying that about everything, there's a little button where you can export all of the data in the table. So say you've done your filters, you've done your sorting, and you say, okay, well, I want to manipulate this data on my own in a spreadsheet. You can click that and it'll export all the data, and you can, if you're a spreadsheet wizard, which I know some of you are, you can just play with that yourself and have all of that information in one place. So it's really, really neat. There's also this little information button off to the side. So it's the same information that's in the pop-up box if you're clicking on the map viewer. But if you click this little eye icon, it'll take you to this detail page. I think it's a little more readable than the previous version, and everything is hyperlinked. So if you want to email a general manager or visit their website, see a link to their management plan or enabling legislation, that's all hyperlinked here on this page. And with that, I will finish up. I'm about to give out some door prizes, so keep listening to me. But before that, any questions? Okay. Well, there's my email address. You all probably know where to find me. If you ever have any questions about it, let me know. And with that, I will move on to a few other announcements before our break. As Leah mentioned earlier, this is the last chance to do exhibitor bingo. We'll draw those names we have 2 $100 Visa gift cards. And so far, we have had 6 people complete the challenge. So right now, the odds are pretty good if you want to go knock that out. Anyone who visits at least 15 of those exhibitors, so that's the majority. We know a few of them have left. If y'all visit those and have 75 points, we'll stick you in the drawing, and we'll do that a little bit later. I also have let's see, where's my 4-H ambassador friend? Megan is back there. Okay, so I am about to issue a few door prizes. My 4-H water ambassador friend back there, Megan, is going to pass them out to our winners. If you are one of those like 40-ish GCD sponsors of the Water Ambassadors Program, make sure you stop by their table to get your plaque. They don't want to take those home, and they want to take a picture with you and everything. So please make sure you do that before you head out. So with that, the door prize I have right now is a gift certificate to New Braunfels Smokehouse. It's obviously a New Braunfels company. They have like cheeses, amazing jerkies and stuff like that. You could even order like a Thanksgiving turkey, pre-cooked and everything. That's pretty cool. And so we have 2 winners for that. First one is Kevin Urbancic. I know he was here yesterday. Is he here today? Got him? Okay, all right. And Natalie Robinson. Do we have Natalie today? I've got some backups. Last call for Natalie. All right, what about Jennifer McClendon? We got her. All right, awesome. Well, congratulations. And so with that, we will take our morning break. We'll see you back here at 10:30. Thank you.
All right, we're going to get going here. If folks want to start making their way back in and finding their seats. All right, well, welcome back. I want to give one last thank you to our door prize sponsors, Middle Pecos Groundwater Conservation District, Fancher Legal, and Red River GCD. And also thank you to NTERRA and the EAA for being our break sponsor for this year's summit. Next up, we have a keynote address. I'm delighted to introduce Commissioner Emily Lindley. Commissioner Lindley was appointed by Governor Greg Abbott in 2018. Her career has been dedicated to protecting the water resources of Texas, having held a variety of positions at TCEQ, including Special Assistant to the Office of Water's Deputy Director, and most recently at EPA's Region 6 Chief of Staff. She's worked with the International Boundary Water Commission and the Texas Environmental Flows Advisory Group. She's also worked on issues related to produced water, which we talked about on Tuesday. We're delighted to have Commissioner Lindley here with us today. I believe this might be your first summit. Let's give her a warm welcome.
Good morning. Thanks for coming out on day 3 of your conference. I've been to enough conferences to know that, you might have stayed up late last night and enjoyed all that the hotel has to offer, but I appreciate y'all being here and getting to see you. I'm going to talk about some stuff happening at the agency. I'll talk a little about groundwater stuff. I'm also just going to talk a little bit about things happening within the Office of Water. And then I'm going to mention what's happening with Sunset, because the TCEQ is going through the Sunset process. And then I'm going to mention a little bit about our legislative appropriations request. Oops, and I got up here, I had my phone out to bring the clock. I don't have my watch on, so please don't let me go on. Yeah, that'll be good. Okay, I will say first and foremost, while I'm going to talk about Office of Water things, I'm not here to announce who our new director is for the Office of Water. Earl Lott, who y'all might have gotten to know when he was director, retired at the end of July, sadly, and we're working on filling that position, but we don't have it yet. That person yet. So let me talk first about what the Texas Groundwater Protection Committee has going on, some of the activities they're working on. So most of their work is performed in quarterly meetings, and it's through the efforts of 2 different subcommittees. And some of y'all, my understanding, there's a few people here that might be pretty familiar with what's happening there, so I apologize if this is a little boring, but I'm going to run through quickly kind of what they're working on and what they're gearing up for over the next couple months. So as part of the Texas Groundwater Protection Strategy, the Groundwater Issues Subcommittee, which is one of the 2, develops white papers on different groundwater issues, and some of y'all might be very familiar with those white papers and worked on them yourselves. They are recommendations that are approved during the last biennium, bringing the total number of the TGPC white papers to 7 that are out there. Those white paper topics include priority groundwater management areas, on-site sewage facilities, transboundary aquifers, wellhead impacts from flooding. I'm going to have to say this word 3 or 4 times, and it trips me up every time. Evapotranspiration networks. I might just call them ET. I think y'all know what that will stand for, and that's easier for me to say. And then they also, there's topics on there that deal with aquifer storage and recovery. These white papers are available on the Groundwater Issues Subcommittee's webpage. If you're not familiar with it, I would encourage you to get familiar. The Texas Groundwater Protections Committee Public Outreach and Education Subcommittee activities have 2 overarching themes. Those are the protection of human health from contaminated groundwater that contains high levels of naturally occurring compounds, and the protection of groundwater from contamination. The current Public Outreach and Education Subcommittee activities are focused specifically on 3 different topic areas: abandoned water wells, the Texas Well Owner Network, and the Texas ET networks. For each topic, the Public Outreach and Education Subcommittee identifies the most important ground-related messages, the audiences, and the actions that would deliver those messages to the public, hence the outreach. During 2021 and the first half of 2022, Texas A&M AgriLife Extension conducted several TGPC-supported educational events targeting domestic well water owners. Different TGPC-supported drinking water fact sheets were used in conjunction with their water well testing program. As part of each of these events, participants are encouraged to contact a licensed water well driller and/or the local groundwater conservation district to decommission water wells that are not in use or deteriorated. An outreach event status report listing both recent and upcoming TGPC booth displays and water well screened events is updated on the Public Outreach Education Subcommittee webpage before each quarterly meeting. The TGPC website is frequently updated with new information on groundwater protection activities. In addition to providing information about TGPC business to its members and the public, the website's also a clearinghouse for many groundwater-related topics, supplying links to the websites and publications of TGPC members and other organizations. The Public Outreach and Education Subcommittee has developed a total of 46 frequently asked questions, including 4 during this current biennium. Well, I guess the biennium just ended. These FAQs are 1 to 2 page summaries of topics related to groundwater quantity and groundwater quality. FAQs, as you all probably know, are the most cost-effective means of outreach, and so they're posted on the TGPC website, along with 10 links to member agency FAQs. An email subscription service with over 6,600 recipients is used to notify the public of upcoming meetings and new TGPC website information. TGPC website activity during the biennium averaged about 34 new and returning visitors per day. TGPC produced and published annual joint reports during the previous 2 calendar years, 20 and 21, which is required by the Texas Water Code, Chapter 26. Monitoring groundwater quality for regulatory requirements occurred in about 45,000 monitor wells statewide in 2021. The joint report documents a 2-year decrease in cases of contamination. There were 3,035 groundwater contamination cases in 2020, and there were 2,929 cases in 2021. The most common contaminants originated from leaking petroleum storage tanks. For 2021, about 81% of the cases under TCEQ's jurisdiction, and about 81% of the cases were under our jurisdiction, about 19% were under the railroad jurisdiction. TGPC, through the TCEQ, have developed and maintain a groundwater contamination viewer. This interactive online map allows users to query and obtain spatial relationship information about groundwater contamination cases. Further, during fiscal years 21 and 22, TCEQ mailed 789 notices for 93 cases of groundwater contamination that might affect private drinking water wells, which is in accordance again with Chapter 26 of the Water Code. They have, TGPC has prepared a final draft report that will go to the 88th legislature. It's currently being reviewed by the members, and it will be considered for approval at TGPC's October 19th meeting. And then it will be submitted to the legislature before session starts, so by the end of the year. TGPC has reviewed its statutory guidance and recommendations, and it recommends that the legislature reconsider TGPC's membership and review its present powers and duties. The final draft recommendation report includes the following. 1, to add Texas Parks and Wildlife Department as a TGPC member. Next, to amend language to move the annual TGPC joint report due date from April to June. It proposes amending language considering pesticide management plans, amending language concerning groundwater contamination notices, establishing a fund to plug abandoned water wells, amending the statute to require sellers to disclose all known water wells during the real estate disclosure process, establish a statewide ET network, support agency programs or initiatives concerning groundwater, and that was the last recommendation. And I think you might have heard a little bit of talk of, those topics might have come up previously. I think maybe yesterday you heard a little bit of discussion, maybe from a member about, establishing a fund to plug abandoned water wells, which is interesting, and we'll see what happens there. TGPC has long recognized abandoned domestic, municipal, industrial, irrigation, and livestock water wells and the most significant threats to groundwater quality. TGPC recommends that the legislature provide positive incentives for landowner-initiated closure of abandoned and/or deteriorated water wells through the establishment of a statewide abandoned water well plugging fund. TGPC supports the 2019 Legislative Budget Board staff report that suggested a statewide abandoned water well plugging program and fund that be established. It's held outside of the general revenue fund, but retained within the state treasury. This program would be administered by GCDs within their territories and by TDLR in areas of the state that are not served by GCD. TGPC recommends that the legislature amend the statute to require sellers to disclose all known water wells, whether active or abandoned, during the real estate disclosure process, and to require that TDLR be notified if an abandoned water well is identified. The 2019 LBB report also suggested amending statute to increase information reported to buyers and to the state about abandoned wells during the real estate disclosure process. Anyway, I think I was repetitive. It would also be required that the seller convey to the buyer the legal consequences of having an abandoned well before the final sale, and TDLR must be notified immediately of this condition. Over the last few years, TGPC has become aware that some landowners don't realize their liability associated with the conversion of abandoned oil well into a water well, a process that requires an application to the Railroad Commission on a form identified as Form P13. When a landowner signs a Form P13, they assume certain responsibilities for plugging the reconditioned water well, should the water well become deteriorate and threaten groundwater resources. It's important for the landowner to understand the liability for owning an abandoned oil well that's been converted into a water well and the potential cost to plug the well should it, deteriorate. To this end, TGPC is updating the existing Can I Convert an Abandoned Oil or Gas Well into a Water Well FAQ, and the Railroad Commission is working to add Form P13, that FAQ, to their website. So that's kind of my TGPC update. So let me mention a few other things that are going on at the agency that are water related and then kind of money related. We always have water issues that are keeping us very busy. Obviously, one item we've been very busy with this summer is the drought, which has affected just about everyone in Texas. We've had 2 priority calls made this summer, and I think probably most of y'all are familiar with what a priority call is, so I won't get into that, but if you need to know more, I'm happy to discuss it. They were both made outside of a water master area. They were both on the Colorado, and when we went out there, there was water present as both of those, so we didn't have to suspend any water rights. There have been a number of suspensions done by our water masters in the area on the basins where we have water masters. Most of those have been temporary water rights that have been suspended, but that has been ongoing all summer. We also have an interagency work group that's a drought task force group that we created years ago, and that's been initiated, and they've been actively working all summer. We also participate in the Drought Preparedness Council Emergency Drinking Water Task Force, which is a larger statewide task force. I will tell you, as far as public water systems, I think most of you probably know this, but they are required to notify us, the TCEQ, whenever they initiate any water restrictions that they have put in place in order to implement their drought contingency plans. So I've got a few stats I want to read off because I always think that's kind of interesting about water restrictions. And again, this is all through self-reported data that they're required by statute to report to us. Of the 7,114 systems in the state, 466 are currently implementing outdoor water use restrictions. Of those 466, 349 systems are implementing a mandatory watering schedule, and 117 are implementing a voluntary watering schedule. 46 systems have prohibited all outside watering. Public water systems are also required to determine the available water supply they have and report to the TCEQ when the supply is less than 180 days, and that's all done through an online portal that we have on our website. We actively monitor the public water systems, especially those that are reporting to us they have 180 days less or less. And we work with them to help remedy their problems, and that could be through a number of different ways, whether it's interconnects or finding funding that might be available for them to use to secure more water, just conservation efforts, that kind of thing. As of the 26th, there are 16 public water systems serving a total of 30,830 people that have reported having less than 180-day supply of water. And I will tell you, 3 of those utilize surface water, 13 utilize groundwater. I will mention real quick, next Wednesday before the commission, we're taking a vote on a water quality standards rule. I'm not sure how much interest this group would really have in it, but I just thought I would mention it. It deals with Chapter 307, which is our Texas Surface Water Quality Standards. It's been out for proposal, and it comes before the commission next week for adoption. So we received a whole lot of comments on it, but I don't think we received any from y'all. But it's a pretty big rulemaking. Let me switch gears a little while we're still talking about water supply and mention Senate Bill 3 that came out of the last legislative session. Senate Bill 3, as you probably are all very familiar, was kind of the bill for, I don't know, lack of a better way of saying that, dealt with Winter Storm Uri. And we do have a piece of that legislation that we are required to enact and enforce and all that kind of good stuff. The biggest piece of that, and you might be familiar with the term, is an emergency preparedness plan. I don't know. Did any of y'all familiar with that term? Anyway, the background is pretty quick after the storm happened that March, it happened in February, that March, the commissioners gathered and we had what we call a work session, which is an open meeting where we can all get together and be in the same room and talk, and it's, follows the Open Meetings Act. And we directed staff to go do an after-action review and come back and bring it to us and say, what does the TCEQ need to be doing to make sure that public water systems don't have the issues that they had during the winter storm, if there is anything we can do. So we created an interdisciplinary team, mostly folks from our Office of Water and then a lot of folks from our Office of Compliance and Enforcement, and sent them out to go meet with stakeholders. We had, I think, how many was it? We had 6 roundtable discussions last summer throughout the months, and I can't remember how many other meetings we had on top of that, but we developed a survey for all the public water systems. We sent it out, and it was just, a number of questions saying what happened, what can be improved, what did you learn, a survey. We got about 400 responses received, which is a lot, but when you think about how we, regulate 7,000, it's a small percentage. But we're going off of the data that we have from what people supplied us. We have reviewed our rules and regulations. The project team that worked on that did a very extensive review of our rules, and have found that there's a few things we need to tweak within our rules. One of the biggest things we found, and one of the biggest needs we heard from public water systems, was we need more training, a lot more training. And so, we don't need statutory authority to do that. We don't need to update a rule in order to provide more training. So staff has been working very hard and very actively over the past year to communicate with water systems all over the state and say, and provide, we've updated training manuals, we've sat down, we worked with them, we've answered the questions they have, and we've partnered with EPA on a lot of things and done a lot of, we did a resiliency workshop with EPA, that kind of stuff. And so a lot of it's been resiliency training, but we've been actively working on that with people. The follow-up to that came before us this spring. The interagency staff presented to the commissioners again kind of what they had found through the survey, what they had learned from meeting with people and talking to people. And so out of that, there are about 14 recommendations that came in front of the commissioners. And we said, sounds great, let's get after it. 7 of them can be accomplished just us updating manuals, us updating different little regulatory requirements we have that are not necessarily based in rule or statute, that are already happening and already done. The other 7 are, I should say probably, it's either 6 or 7, will require rulemaking, and that rulemaking is probably going to come before the commission in September this month. this year, I should say. And so, if you're engaged with the water system, it will likely affect you. There is one recommendation that will require statutory change, and so we're going to go seek that from the legislature. And if you really want to know about all the recommendations, I can get into them. But I will tell you, probably the most controversial one, if I had to guess, will be for those. Well, I'll just read it how it's probably going to be written out. We're going to be adding requirements to increase the duration of fuel storage for public water systems and affected utilities with an on-site generator or plan to use an on-site generator during emergency operations. So I think why this will be controversial, and the reason why I'm even mentioning, even though I know it probably doesn't affect a whole lot of y'all, but I really want input on this item, is because if we're going to be saying you need to have fuel on site to operate a generator if you plan on using a generator so that we don't have, a water outage during a storm, how much fuel is appropriate to keep on site? Right now, the rule says 8 hours, and all the surveys, everyone we heard from across the state said it needs to be more than that, but what's the right number? And so staff is going to put a number, of how many hours of fuel storage you should have, but if you think about it, if you're a big city, if you're San Antonio, if you're Houston, that's a whole lot of fuel that you're going to have to store on site. And if you're storing fuel, there's other requirements that you have to, all of a sudden you might need an air permit. I mean, we've kicked you into a category of, requirements that you might not be used to having. So the reason why I mention that is because everyone agrees it needs to be more than 8, right? That storm was days long. But what's the magic number? And again, this won't affect every water system. It's just those that say they're going to be keeping a on-site generator or plan to utilize an on-site generator during emergency. But that's a tough one to answer. And I'm learning there's a whole lot of requirements. There's a whole lot about fuel that, I don't necessarily know. Fuel can't just sit in a tank for a long time. It's got to move. It's got to turn over, for lack of a better term. And so if we're going to require you to have days worth of fuel, how are you going to do that? How are you going to maintain that? So that's, if I had to guess, my guess is that's going to be the most difficult recommendation to work through, and that'll be through a rulemaking at the agencies. So if you have thoughts, I have called people already and said, you got to tell me what you think about this because we want to get it right, but we've got to up that number. But what's the right number? So tossing that out there. That's truly a matter I'm all ears on. And, commissioners at the agency, a lot of times we don't have the ability to talk to you about anything pending. So anything like a permit, anything like a enforcement matter we can't talk about, but rulemakings I can talk about. So let's talk about it. What I will, I've got like a couple more things to mention. I'm going to skip forward to probably some stats because I got the 5-minute window here to mention this, and I really want to. So I will tell you before I get into my stats, if y'all are familiar with our Sunset Report, there was really only one little line mentioned about groundwater, and it said the Sunset recommended a statutory requirement that TCEQ hold its annual meeting regarding priority groundwater management areas in a public setting, and we responded with the will of the legislature, whatever they want. That's what they want to vote and put in the report. Okay, we'll do it. Don't feel real strongly about that item. Other ones we do. But let me mention this real quick. So like everyone out there, we have workforce issues. And so some of these numbers I want to read off just so y'all understand what we're working with. They're pretty wild. We're a very large agency. We have almost 2,900 employees. We currently have 429 vacancies, which is a significant amount. Last week we had a work session to hear updates on what is happening. What are we doing to try and retain our employees? What are we working on to improve our workforce situation? And there were a lot of numbers that were rattled off. And if you have an interest in it, it's posted on our website. You can go back and watch the work session on it. But there was when you're a state employee and you leave, the state auditor's office, a different agency, sends you a survey basically asking if you'll fill it out. And there's a number of questions that say, why are you leaving, and da-da-da-da. And then every quarter they send us all the surveys that have come in over that past quarter. And so the data I'm going to share with you is from the first 2 quarters of this year. And they're anonymous, so we don't know who the employees are, but this anonymous data that former employees have filled out. So we know from those responses that in the first quarter of this year, 41% of the people that left for better pay. We know the second quarter of this year, 61% left for better pay, or benefits. They lump those into better pay / benefits. We looked at the salary ranges of those employees leaving. 40% made $50,000 to $75,000 in the first quarter. 48% made $50,000 to $75,000 in the second quarter. So it's kind of our entry to middle range employees that we're seeing the highest turnover in. And here's a really, really interesting stat that I want to share. This kind of blew my mind in a good way. For the same data, for the first quarter, 67% of the employees said that they would return to the TCEQ. And for the second quarter, 81% said they would return. So to me, that tells me, okay, it's not that our employees hate their job, it's not that they're unhappy, but they have to go elsewhere for better pay, for better benefits. So that leads me into the last thing I'll mention, which is our legislative appropriations request. You know, like every state agency out there, we're asking for a lot of money, and the bulk of our ask is in order to pay our employees more so that we can keep them, because them turning over quickly is hard on everybody, right? It's hard on us, it's hard on y'all. I will mention that in our Office of Compliance and Enforcement, which is our regional employees mostly, and they're the folks that go out and do the investigations and that kind of thing, of our 429 vacancies, 129 of them are in that division. So, when we're charged with protecting human health and the environment and we have that many vacancies, it becomes a challenge. And so our biggest ask is to get a lot of money, more than I can ever remember us asking for. And with that money, we would be able to touch the bulk of our agency employees and, cross our fingers that helps and makes a difference. We are asking for money for 3 other things, and then I will be done. 2 of them are IT related, and one of them came out of the Sunset Report. They said, hey, y'all's website, whoa, it needs improvement. It's not very searchable. Yeah, y'all are like, amen. Yeah, why am I just now getting to that one? Anyway, so I think the way we're saying it is the agency needs money to improve our usability and make it more user friendly. And Sunset said that in their report. So anyway, I am happy to talk to anyone about our LAR requests anytime. We only have 4. 2 of them are IT, 1 are for employees' salaries, and 1 is for our lease and maintenance at all of our different offices, because they're not all state-owned buildings, and we have to pay leases in some of them, and leases go up and they come up for renewal, and so there's just maintenance costs that we've got to pay for. So with that, I will stop. I don't know. Do I need to take Q&A or move or let?
All right, wonderful. Well, thank you so
Yeah,
much for that.
thank y'all.
Appreciate it. Thank you so much for that, Commissioner Lindley. You definitely have a lot going on at the agency, and appreciate getting those updates and hearing what's been going on. So last but definitely not least, we've got a superstar panel that are coming up right now and taking their seats. They're going to be exploring some of the aspects of one of the less favorite aspects of managing a district, and that is when things kind of get contentious, contested case hearings. Not just the hearing itself, but also navigating those weeks and months that lead up to a potential contested case hearing. We're pleased that we have Mike Gershon, partner at Lloyd Gosling, who has plenty of experience in the contested case hearing world, moderating our panel. I'm going to turn it over to him and let him introduce his panelists. Let's welcome them.
Great. I'm Mike Gershon, and fortunately I've had a good amount of experience working on these issues with our distinguished panel. Let me start with the public official at our group, Blaine Stansberry. You'll see that she is a PE. Blaine is board president of the Barton Springs Edwards Aquifer Conservation District and a very experienced civil engineer. She has recently decided to become a professional educator. This year, she is starting as a high school math teacher, so we're excited about that. Stacy Reese, water attorney like myself, Dr. Bill Hutchison, a PE, a professional engineer and a PG, and Jim Totten, general manager of the Lost Pines Groundwater District. Please look at the bios in the brochure for more about their distinguished careers and background. So we are not here to advocate how to get a permit, and we are not here how to advocate how to defeat a permit. We're here to talk about how you might avoid the fight, and sprinkled throughout our discussion, we'll talk about times that it's appropriate for district representatives, the applicant and protestants to talk informally and try to reach agreement to avoid the fight. We're also going to tell you that if you got to get into the fight, some ideas about how to win it, and from different perspectives. So with that, let me launch. If we could turn to the next slide, please. So, as I mentioned, our goals are to share with you the process and tips, and we'll have some takeaways for the process. As far as the law governing permitting and hearings, the law is Chapter 36 of the Water Code for the most part. Subchapter M has a lot of the procedures, and 36.113 and several of the statutes that follow that section provide for a lot of the meat of how you go about the permitting process. Next slide, please. So let's talk about the applicant's view. You're a landowner, or you have some interest in groundwater, and you need to drill a well, or you need to produce water from and operate a well. For our purposes, we're going to be talking about large volume transfers, not 100 acre feet. We're going to talk in relative terms, but we're talking about large volumes, where it's presumed that the folks involved from all angles, whether they're folks concerned, the applicant or the district, are looking at thousands of acre feet, billions of gallons of water that would be pumped per year. So I'd like to start with Dr. Hutchison. And Dr. Hutchison has worked for a variety of the types of stakeholders. Dr. Hutchison, if you're working for an applicant, what are the types of things that you're counseling that client to do before the application is filed?
Well, before the application is filed, you basically want to look at both regional data and information and local data and information. So regional can count for, or can include GAMS, DFC explanatory reports, those kinds of things, and the historical geologic reports. On a local scale, now you're getting into details on data. We heard a good session the other day on data. The Texas Water Development Board database is unmatched in the country as far as availability of good information that you can rely on in terms of water levels, water quality, well locations, well depths, that sort of thing. So it's really just a matter of, depending on your objectives, focusing either on local or regional or both, and then doing your homework.
What about district information and coordination with the district on data that they have?
Yeah, most districts will have lots of good information also. Just as a default, though, a lot of that information already gets rolled into the Texas Water Development Board database. So there's, I always start with the Water Development Board database and then supplement it with what other detailed information there may be at the district level.
Let's get some legal advice as well. So Stacy, most districts have application forms, they have rules that govern the process, and there are minimal requirements that have to be met. What are your thoughts on counseling any applicant on meeting those minimal requirements or going above and beyond to providing a more robust application?
Sure. First and foremost, we start with, okay, what are the permitting rules? We need to have a thorough understanding of those. What are the application requirements, which, as Mike mentioned, are very specific, enumerated, general types of things. And then there's a catch-all that allows the district to ask for other information. And if they want to ask for other information, it needs to be in their rule. Typically, that could be something like a hydrogeological report where they're looking for an assessment of impacts that your proposed project is going to have on nearby landowners or wells. So even if it's not required under the other information, sometimes it's important to consider doing a hydro report, even if it's not a technical requirement, because there, in another section of Chapter 36, there are considerations that the GCD board must make before they're granting and denying a permit. And those considerations in a contested case hearing situation effectively end up becoming the applicant's burden of proof to establish that they're entitled to receive the permit. And one of those requirements relates to whether or not the proposed use of the project has an unreasonable effect on groundwater and surface water resources and existing permit holders. So even if you're not required to show an analysis of impacts as part of the application process, if you've got a big project, you think it's going to be protested, I talk with my client about whether you need to go talk to Dr. Hutchinson or another technical consultant to get this analysis impact, because ultimately that's going to be something that you're going to have to prove.
Yeah, that's great. So Jim, in your capacity as the general manager, surely you're getting the call, somebody's dropping into your office to visit about an application, making sure they've got the forms. How do you make yourself available, and what do you find helpful for somebody who's wanting to apply to do in engaging with you?
Well, since we've limited the conversation to large permits, unfortunately I'm going to say that I don't really get that kind of interaction. Most of the time it's smaller operations and smaller permits. The larger permit applications tend to have experts and lawyers on staff that I guess take care of everything in advance, so they don't feel the need to compare notes with the general manager. We have had a case in the past where a large application walked through the door, dropped everything off, not realizing that 2 months previously we had changed the forms for the district, and so the application was immediately out and refiled, but a simple visit could have cleared that up before they filed.
So it sounds like implied in your answer is a tip. Call Jim.
Possibly, yes.
Blaine, as an elected board member, you and your directors set policy, you adopt the rules that govern this. You rely on your team, like Jim, to deal with the forms, which are important issues. So from a policy perspective, making a judgment call on how you're going to burden folks that want a lot of water from your district, which the burden would be providing technical information, doing the types of the hydrogeologic reports that Dr. Hutchison and Stacy mentioned. And what are your thoughts on balance in burdening an applicant versus what's important for your board to know to be able to address the criteria that Stacy mentioned? What are your views on that?
Well, sure. The Edwards is special, so we have multiple pages of rules that we have adopted. The Edwards really needs that live data feedback with a test, a hydrogeologic test. So we require a test well to be drilled. We require it to have live data and a report submitted with the application that the applicant provides. We have on-staff PGs that review this application. And this is because the karst nature of the Edwards doesn't respond well to like a desktop study. So we do have to require that investment so that we can really get a good scientific basis of what those potential impacts from their application could be. And then the GM bases their preliminary decision on that science.
Yeah, thanks. Dr. Hutchison, could you share your experience, a couple of districts I'd like to call out and allow you to brag a little bit about, the Bluebonnet District and its two-phase approach to permitting, how that's been useful for all involved, the applicant, staff, the board, and folks who are concerned about impacts from those applications.
Yeah, right. We've heard a little bit from Blaine about the need for a test well in something like the Edwards Aquifer. In the Gulf Coast Aquifer, we don't see that as critical a first step. So our first step in the Bluebonnet District, which is the Gulf Coast Aquifer area northwest of Houston, we require essentially a paper study that focuses on regional impacts of the proposed pumping. And so following the guidelines that we've developed over the years and evolved over the years as we've learned more about the process, what's the most streamlined way to do the process, we require essentially a model simulation that adds the pumping to the current DFC run, so then we can compare with and without, the incremental impact of that well. We find that to be useful as sort of baseline information to be included with the notice of the permit application, to give adjacent landowners just basic information on what the long-term impacts of that pumping would be. That's then followed up by, assuming the permit is issued, then the hole is drilled, the well is tested, and then there's a phase 2 report that's required that focuses more on the local issues. So essentially we start with the regional paper study to give just basic information, then followed by the actual construction of the well and the test of the well, and then that's part of the phase 2 report, which reports on everything that was done as part of the drilling and testing of the well, and then compares that back to the paper study to see if there's consistency on that, and that provides information to the district to update models and processes. It also feeds into the DFC process. So it's a very useful, streamlined approach that actually gets information not only to the district but to the adjacent landowners to make a decision on whether they should protest it or not.
So you have another client in West Texas, the Middle Pecos Groundwater Conservation District. Similar two-step approach, not as formal. Could you describe how that's been helpful?
Right. So just like we talked about, or Blaine talked about, the need to have a well because it's in a karstic environment, and we don't need to have that in the Gulf Coast aquifer. Out in West Texas, we do. We wanted to get some, we issued drilling permits in order to drill the well to see if the site will actually produce water. And so we're not wasting a lot of time processing permit applications for a site that just won't yield the amount of water the applicant wants. So the first step is drill the well, test it, prove up the supply, and then get the permit, the actual production permit.
So let's turn it back to Jim Totten. The ball has landed in your court. The application's been filed, and it isn't your board that takes that next step. You take that next step. Could you describe what happens once you've received the application? How you coordinate with your team, both inside your office as well as your experts that you work with, your hydrogeologists?
Our normal process is pretty straightforward. We kind of follow a two-track process, one of which is all the hydrogeologic information goes out to our consultants there to review, start doing model runs and developing some impact analysis. At the same time, the remainder of the application gets split over to our attorneys. I'll work with the attorneys to go through and make sure that they do have an administratively complete application, verifying the information needed, working with the applicant to get more information if there is a deficiency that needs to be addressed. And then hopefully by the time we get done with that, the hydrologic studies have been done. We can come back and figure out how to proceed with the application from there.
So the application at some point gets declared administratively complete. Those minimal requirements are met. And the statute's pretty clear about then what happens and a timeline for getting notice out. Stacy, could you talk a little bit about that notice, briefly about the 10-day notice, and then how districts have discretion if they want to provide more notice to get out to the public?
Sure. So for a hearing on the permit application, the GCD is required to provide at least 10 days notice. They can provide more, so there's some discretion there. That's really just a policy decision. You have to balance the interests of the general public who wants, more time and more notice versus the applicant who, is likely not going to want to have an extended period of time for notice, leading into this hearing on their application, where it gives people a chance to, sort of formalize and plan and get together and figure out how they're going to, attack the application. So you have to kind of balance those competing interests. There's also, not required by statute, but you can, and some districts do, provide notice of the application once it's filed, which is not required by the statute. There was a bill last session, Senate Bill 152, that incorporated that, where GCDs who had spacing rules were required to provide notice of the application once it's filed to certain landowners in certain circumstances. So I think we expect to see that bill come forward again, but until it becomes a law, that's sort of just a policy decision for the district as to whether they want to go ahead and provide notice of the application.
Thanks, Stacy. So, Jim, back to you. So, whether it's 10 days notice or a little bit more, at some point the public becomes aware of the application. And your phone starts ringing, and your texts start rolling in, and people start showing up at your office. I believe your district also posts large volume applications on the webpage, I believe, in some cases. Some districts do. How do you handle the incoming calls and the concerns of the public?
It kind of depends on the questions that are coming in. By the time that we get to the notice being posted, we've done our own hydrologic studies. We have any data that was supplied by the applicant. So I can pull from those sources to try and address any concerns that come up. I also have, the reports from our attorneys as well that we can kind of reference. Anything that gets beyond that, there's the standard, I don't know, I'll have to get back to you, which seems to work fairly well. Or in extreme cases, there's always the phone number for the applicant's attorney that I can give out too.
And so let's talk about that. Stacy, put yourself in the shoes of the applicant's lawyer. Jim's giving out your number or your client's number, and you're getting that call, 5 days, 6 days before the hearing, the big event at Blaine's show, her board meeting. We'll get back to that. What is your advice to your client on how you're engaging with potential protestants?
I think first it's like, take a deep breath. We're going to get through this. We're going to hope for the best, but plan for the worst. But all kidding aside, I think a lot of it has to do with managing, at least my advice to my clients is managing their expectations about what's going to happen, the process. There's going to be some pushback. There's going to be concern. You need to figure out how you want to address that. Hopefully you've hired other professionals such as, technical professionals who might be able to provide information. Sometimes I think that there can be a frenzy because people don't have the information or there's misinformation out there. So sometimes it can be helpful and I'll, discuss with my clients, you might want to put some of this information out there. You might want to hold some, town hall meetings. If there's a big group, you might want to talk to people one-on-one. Sometimes it's not effective to do that. Sometimes it's helpful for just the lawyers to talk about different things. But first and foremost, you need to have a plan. There's going to be public concern for these big projects. You need to expect it. You need to not take it personally. You need to be respectful and professional. And don't be a jerk in this, and let's try to work through it together.
So I've seen some matters resolved before we get to Blaine's board meeting. Jim, it's my observation, my experience, that often it's the general manager that's encouraging engagement between concerned citizens and you and the applicant. What are your thoughts on that role that you can play before the board meeting day?
I've certainly in the past tried to encourage applicants that have contentious permits to get out there and be their own advocates. The district's job is not to advocate for any particular application or any particular applicant. If you know there's going to be a public issue or a public concern, then it's incumbent upon the applicant to try and get out there and help address some of those issues. As the GM, any information I can supply to kind of work in that process is certainly something we'd like to do, but ultimately a lot of it is incumbent upon the applicants to try and help sort that out for themselves.
Yeah, so Blaine, word's out on the street about the application. Your board meeting has been publicly noticed two times under the Open Meetings Act and under this 10-day notice. You're an elected official. Your constituent may be the applicant, and your constituents may include concerned constituents and your phone starts ringing. How do you manage that? What is your experience?
Ooh, that is such a fine line to walk. First of all, we include a 20-day comment period when we submit the notice, and that is a strategic step that we take because it is a formal way that we can gather in the comments. And by the time it comes to that public hearing, we typically know if the application is going to be contested. We typically know if a request for a SOA referral has been made. So this is all good information we have before we get to the actual hearing. But if my phone starts ringing and I have a sense that that case is going to be contested, then I have to let my constituent know that, as a board member, I'm one of 5 people that are going to be the final decision makers in this hearing. We are in fact the judge, and I cannot talk about this case. Otherwise, I could jeopardize my ability to act on a final decision. So I refer them to the general manager.
So Stacy, the legislature has told districts you've got some discretion in how you recognize the opportunity for folks to protest. And I'd like for you to focus on the deadline. There is discretion to set a deadline to protest that's before or at the hearing. What are your views on that, from the district's perspective as well as those other perspectives from the other stakeholders?
Sure. You can do it well in advance of the hearing on the application. You can set the deadline to notify that you're going to protest the application. You could set it for at the hearing. You're also required to set a deadline for requesting the case to be referred to SOA as well, and you can do that before the hearing or at the hearing. I think doing it in advance, requiring it in advance, is really helpful for the reasons that Blaine discussed, because you're going into it and you already know who's going to protest and who's requesting an application. You don't know yet whether those protestants are going to ultimately be parties in the case, because there's a standing analysis that has to be done later, but at least you know who's interested. And so I think it helps you get more organized. I also think there's some downsides to doing it, in advance, because sometimes people don't have enough information to determine whether they want to protest. And so they may protest out of an abundance of caution to not waive their right. And then sometimes, while they can then later withdraw the request, sometimes what happens with these big applications is you get a bit of a frenzy going on. And so one person files a request for a protest and then many do. And then even if the original person, withdraws the application, you're still got all these other folks involved. So there are pros and cons to doing it early or doing it at the hearing, but I think the important thing is to understand the pros and cons and develop a system that works for you.
Yeah, good. So it's board meeting day, and the ball's back in the court of Madam Chairwoman. Back to Blaine. You're in charge. Chapter 36 of the Water Code says, the board is there, they've got your back, they're with you, but you are the presiding officer as the board president. And so and it's very express in the statute that there are certain decisions that you alone can make. You have options for how you want to manage, which with a large volume application, maybe chaos out in the parking lot. When they walk through your door, you have some ability to control, with your staff's help, how things look, what information is available, what guidance you're sharing, you're having your staff share informally. But then you call the meeting to order, and then you call the hearing to order. In your experience, what's been the best approach to manage a large volume application?
So in this kind of first hearing, we treat it more as a preliminary hearing. We've had our comments come in, we've got a sense of what's going on, and the case is going to be contested. And so we take that opportunity to explain the process to the public, that if this case is contested, this is going to a formal hearing, and the board needs to decide how that is going to be heard, how the hearing is going to take place. And so that there's several options that we're going to get into that the board can decide. But also at this preliminary hearing, people like to be heard. And so I usually entertain an ordered public comment where we have people sign up to speak. They're limited in their time that they can offer comments. But with contested cases, it's a little tricky in that sometimes the board can't consider the public comments in the final decision. So I would need to refer to our attorney to help inform the public of how their comments will be part of this application. But at least they know somebody heard them. But it does have to be very, very ordered. The facility needs to be big enough. Typically, you can change, you haven't, if you know it's contested, you have enough warning to find a larger facility if you need to. But that's normally how we handle it. But the big decision on the board that day is what of the three options for this hearing are we going to do?
So, Stacy, you are often sitting to the left or the right of the board president and whispering back and forth about how it's going. Before that, you all have certainly talked about how it's going to go. What are your thoughts from the lawyer's view?
Are you talking about the hearing before the GCD board?
Well, the day of the board meeting, the preliminary hearing, the main event, and how procedurally it's managed.
It needs to be organized. When all else fails, a continuance is always a good thing to do. If you're not organized, you get caught off guard or you're surprised that continuances are allowed. You don't have to provide notice of the hearing again if you do continue the hearing. You can, decide at the hearing when you're going to reset it and tell the public at that time, hey, we're going to continue it for this date and time. If you don't announce it at the hearing, then you can then later you're required to notify the parties in writing of when the date and time will occur of the continued hearing. I think it's helpful that, you can be sitting next to the president and maybe kind of acting as the co-presiding officer and answering questions. If you get standing questions, you're going to be discussing that.
And if you could elaborate on that, the timing of deciding when, whether the board wants to decide the party status issue, when, and how they go about that.
Sure. So before you can, conduct the contested case hearing, you need to decide who's going to be parties to the hearing. And you have these people who have filed these requests to be, contest the application and be a party. But you have to determine before you can convene the actual contested case whether or not they meet the requirement to do that. And so we shorthandedly call that standing. It's a legal test, and you have to have a justiciable interest that's within the jurisdiction, related to a right that's within the jurisdiction of the district, and that's not common to the public, basically. And the GCD can decide that issue on their own, or ultimately, if the case is going to be referred to SOA, they can let SOA decide that issue. Because it involves a legal test, you basically have the elements of the legal test and what the law is. And then you have to look at each protestant and say, okay, what are your facts related to this test? And then you have to apply the facts to the law and then decide whether or not they've met that standard. So sometimes it's helpful to have that established at SOA because there is a lot of, analysis of the law and the application of the law to the facts, which directors don't necessarily feel comfortable doing. If they appoint a hearing examiner to conduct the hearing, that hearing examiner, would make that determination and might have more of the expertise or skill set to do that.
Yeah, so good segue here. Most applications are heard by the board of directors. In my experience, that's usually how it goes. We know that Chapter 36 gives districts some discretion, not to burden the board or to hire a hearings examiner to conduct the hearing. And we're not talking about a hearings examiner, an administrative law judge at the State Office of Administrative Hearings. We're talking about a private hearings examiner. Chapter 36 says that. Or we can go to what we'll be referring to as SOA. I'd like to open it up for the panel. I know a number of y'all have experience doing it a variety of ways. And so I'll open it up for y'all to talk about some of the pros and cons of doing it before the board or going to SOA, or what's rare, at least in my experience, bringing in a hearings examiner.
Well, I'll go first. This is what I was talking about. The board needs to decide at that preliminary hearing. These three different paths that are all so very different, and they are going to impact so many people's time, and it's going to cost money. I mean, the first one is the board doing it themselves. There is so much legal stuff. It's like an entirely different language, in my opinion. And so for the board to conduct that hearing, I've got to have an attorney right there by my side the entire time, explaining all of the different terms, all of the different processes, all of the different steps. Constant feedback on what is going on, and really just holding my hand through that process. As you know, I am not an attorney, but this is a very legal process. And so the board needs to pay for that attorney, which is going to be a lot of time on the board, the entire board, to hear evidence, to do the process. And that's going to be a lot of time on the board and a lot of money for the board. And it's also a contested case in any process is going to be a lot of time on staff. That's just a given. The second step is the hearings examiner, where that takes the time burden off of the board, because the hearings examiner would have experience with that and would conduct the hearing and provide a recommendation back to the board. But that's still going to cost the board a lot of money, because you're paying for an attorney at their regular hourly rate. The third option is the SOA option, where the administrative law judge takes in all the evidence, conducts the hearing, all the steps, and provides a proposal for decision back to the board. That one is basically SOA doing all of the work at a relatively reasonable rate.
For all the reasons, I think that was an excellent explanation. I think it's time intensive for staff. It involves a lot of legal stuff. You're going to be paying lawyers and consultants anyway. So, going to the SOA venue can be helpful. It was enacted originally to provide an impartial venue for people to resolve these disputes. I think it's really helpful for the board because, they're not facing all this political pressure from their constituents about what you're going to do about this. Are you going to rule on my standing? Are you going to tell me I can't have a seat at the table? Or are you going to rule against me in my application? So I think having it removed to SOA, having an ALJ who's experienced in making all of these decisions and weighing the evidence is very helpful. When the PFD or proposal for decision comes back to the board, if you do go to SOA, the board can only change that PFD in limited circumstances. And so you're in this impartial venue. You have all the people who have the expertise in this area to develop the record, which, by the way, the record is what will be used in an appeal. So the record becomes extremely important in this process, because if the application is appealed, you cannot put on new evidence in the appeal. You only have the record from the hearing. And so it becomes very important what type of evidence is submitted, who it's submitted by, if contrary evidence is submitted to rebut weaknesses in your case. So all of that becomes extremely important. And when it comes back to the GCD from SOA, they can only change it in limited circumstances. So, in my mind, I think it gives the GCD board some cover because they can't, they're confined and limited, and they kind of have to follow what the ALJ says, except in unique circumstances. And I think that the applicant, feels more comfortable with this impartial venue, with these people who are, do this every day. And I think the protestants appreciate kind of the formal structure of it and their ability to really be heard, and it not sort of be, less structured and less formal. Not that the districts aren't capable of doing it, but I just think there are a lot of considerations.
Yeah, and there are a lot. And there are pros and cons. And I'd like to look at some of the cons. Jim and Bill, they're dragging you over to SOA, which means you guys are the only two on this panel who get to take the stand and sworn in and do all the things involving getting deposed and getting cross-examined. With all seriousness, I'd like to hear from both of y'all about time commitment. We know, we can cover this quickly. You're before the board, and you may be in and out in some districts, even with a large volume permit application, in a matter of months, a handful of months. That is possible, even with a large volume application. We know that you're not going to get through the process at SOA in a handful of months. It's a time-intensive process that has some expense. I'll stop talking. You all comment on your experiences doing it both ways. I know, Bill, you've had experiences both ways, and Jim, I think you have as well, but primarily at SOA.
Go ahead, Bill.
Yeah, obviously, the more formal the process, the more time it takes. I mean, that's just sort of axiomatic. If you are developing, from a technical perspective, if you've developed reports, those are useful in either a formal or informal setting. So a lot of the preparatory work really shouldn't matter whether it's going to be a big deal formal SOA hearing or a hearing in front of the GCD board, because you're still, at least from a technical perspective, your responsibility is to provide information that is useful in the decision. Part and parcel of that is understanding what the where the protestants are coming from. What are their issues? Is there something legitimate about a particular set of wells or nearby property owners, or is it something related to impacts on a spring or a river? You know, those kinds of things. You need to know what those elements are of the protestants, so your analysis can be tailored to answer the question.
Anything to add to that, Jim?
Yeah. All of my experience has been through SOA. We've never actually used a hearings examiner or conducted the hearings through the board. I will say that in working through that process, it is time consuming, but the ability to develop pre-filed testimony, I think, is absolutely critical to moving things along a little bit more quickly. The ability for every party to file their written testimony well in advance just makes things a little bit more smooth and a little bit takes some of the surprises out of things.
Let's talk about the handoff from the district to SOA. So somebody's requested, or the board has decided that we're going to SOA. Stacy, I'd like to combine a couple of questions that involve what that handoff looks like. Chapter 36 says that a district can, adopt rules that SOA has to follow, and I'd like for you to address that. And then second, Chapter 36 also says that a district isn't supposed to micromanage what the ALJ, the administrative law judges, are doing at SOA, but they can provide information to SOA. They can provide the rules, they can provide policy. I believe that includes sharing information about district precedent. Thoughts on what that handoff looks like and what you would counsel your groundwater district's board to do in making that referral?
So with respect to the first part of your question about developing rules specific to SOA, whether the GCD should do that, Chapter 36 allows you to do that, but your rules have to be consistent with the SOA rules, basically. Provisions of the Administrative Procedure Act that are incorporated in Chapter 36. So I think if this is your first time going to SOA as a GCD, I don't think you're going to know what rules you might want to have that, sort of complement the SOA rules. But if you're really experienced like Jim and Blaine, it might make sense for your GCD to do that. I'm not sure doing it sort of preemptively is necessarily something that I would recommend, but I think if there are lessons learned, it might make sense later to incorporate having your own rules about specific procedures at SOA. And if you don't have them, then you just follow the regular rules at SOA. Your second question was, politely remind me again.
Yeah, precedent, policies, information that you can share with SOA. And the statute's clear, it has to be on the front end. Not supposed to influence the judges, and so before a judge is even assigned, there's interaction between the district and the administrative team at SOA, and there's a handoff of what information that the district wants to share. Thoughts on that?
I think it's important from the district perspective, most certainly. It can be your rules, it can be policies, and it can be decisions or precedent. And, in all of the contested cases I've worked on, those all become an issue. What are the district's rules? What were the district's rules at the time the application was filed? What does that rule say? We're going to get into the details of all of that. How has the district handled this situation in the past? Are there written policies on it, or are there practices about it? And what precedent do we have? So I think it's an opportunity for the district to educate the ALJ and give them a preview of, sort of not ultimately their position, but what's the framework within which you're going to be making this decision. And a lot of ALJs, so we have more now who are more familiar with groundwater permit application contests. But when this first started and was put in the statute, there were no ALJs who had any experience. So I think that was hugely helpful to them. We have ALJs who are more educated about, groundwater permit applications. Of course, they're very educated about process and procedure, but the nuances of a groundwater permit application versus some other application that a regulator has authority over is very different. So I think it's important, and you should certainly take advantage of that. And if you don't put it in the record and give it, then it's not going to be available to talk about.
Yeah, could we get some help moving to the next slide, please? So we're going to dig in a little bit harder on what SOA procedure and the mechanics look like. But first, I'd like to talk about the types of hearings that many of the districts around the state are having before the board. So the contested case hearing itself can be short. It can happen the day of the board meeting that we've just briefly described. Or it can be continued. As Stacy mentioned, might be agreed to by everyone in the room. Folks need to get organized. It can be informal. It can be formal. Blaine has some options in how she decides on the fly as she's seeing who's showing up that day, what the best approach is going to be. If there's not going to be a continuance and everybody is ready to move on, how to manage what that looks like. So what I'd like to do, I'd like to start with Bill. Bill has experience with really formal and less formal hearings before boards. So if you could share your experience, and let's focus on, as a scientist, whether you're a PG, a PE, or somebody that's a lay witness, knows a lot about their water and their well, what you do to persuade the board of your position. You're needing to put a case on the merits on. So what are you doing to get organized, and what is your counsel to your client to be ready to roll the day of the board meeting?
Yeah, in the more informal ones where it's a relatively small amount of water and it's just going to be, the hearing is going to be that day, whether it's contested or uncontested, a lot of the issue comes down to, is this well going to cause an impact? And then also, in other areas, you may wind up with a question related to the amount of water that's being produced on a per acre basis for their parcel that they own. So those are two kind of not unrelated questions, but somewhat different. From a impact assessment, recognizing that, you know, what other permits have been issued by that district and understanding what they look at in terms of what is a reasonable or unreasonable impact, being prepared to answer those kinds of questions, being able to answer questions about, well, this is X number of acre feet over a certain number of acres, how does that compare to other permits in the area? So it's really, from a technical standpoint, it's really about doing homework and understanding what has been processed and approved in the past in order to answer questions effectively.
Yeah, so Stacy, what Bill is talking about is he's going to be sworn in, and he's going to have something to say that you and I call the record. The record that at some day our Texas Supreme Court justices might be looking at, deciding whether it was convincing or whether an expert's thoughts on the matter support what Dr. Hutchison has to say. Talk to us about what the record looks like. And in the simplest of ways, I mean, our boards, they've got to turn on the digital recording or have a court reporter or have somebody taking minutes. So talk to us both fundamentally about having the record, and then your advice from everybody in the room's perspective on the importance of that record as you move through other legal steps.
And and I'll focus kind of in an informal before the GCD board because it's really well established and kind of not going to not happen. There's going to be a record, but at the GCD level, you know, you want to make sure that, you know, before witnesses start testifying that they're sworn in, there needs to be a record. You want to make sure that there's a court reporter, that there's, you know, it's being recorded, or someone's taking minutes, because that record then closes at the end of the final hearing, and then if there's an appeal, it gets, you know, requested and provided to the district court who is hearing the appeal, and that is the record. And you go back and you look at it, and if what isn't in there doesn't, you know, can't be considered. So very important. I think that the presiding officer, whoever that ends up being, if it's the board president or if they have appointed a hearing examiner acting as the presiding officer, it's really important for that presiding officer to know what their powers are. And Chapter 36 specifically lists, these are the, you know, the duties and powers of the presiding officer in terms of considering evidence. You can exclude evidence that is not relevant, evidence that is repetitious. So there's a way to not overwhelm the record, but at the same time, there's certain, you know, practice, like policies and procedures that need to be followed. And those are all listed in Chapter 36 about limiting the evidence, how much you want, what types of discovery. I guess in the hearing on the day of, you're not necessarily going to have a lot of discovery. So, but simpler is better. But have a plan.
Right. So, Blaine, Jim, your large volume application's probably going to SOA. But if you could share your thoughts, assuming that we were going to move forward on the board with the board, if there's anything that you think might be helpful to provide some efficiencies in getting everybody in the room kind of down the road and comfortable that there was due process, that there was fairness in the proceeding.
So for that question, it's not so much about what the other parties need to do to be prepared. It's about what I need to do to be prepared. And so in advance of that, I would need one-on-one counsel conversation with the attorney so that we could, create this outline of how these steps are going to go. So my preparation is the key for me from a board perspective.
Yeah, that's good. I don't know if you have anything to add, Jim?
Luckily, I don't. That is a challenge for the board to try and wade through, and that's typically why we do send things out to SOA, just to avoid having to, figure that out for us.
So let's take it to SOA, and let's talk about the preparation if we're headed to SOA. We all know that that first preliminary hearing before SOA is not likely to be any sooner, any earlier than 2 months. It could be longer. There is some internal coordination at SOA about how the case is going to be managed, who's going to handle it, where the hearing is going to be, because it could be within your district's boundaries. It could be back at Austin. And so, Stacy, I'd like for you to spend a little bit of time talking about, with that time that you've got, months, you've got several weeks to prepare, what your district's general manager, what your applicant, what the protestants are thinking about with the time that they've got to get prepared.
Right, and so typically at the preliminary hearing, if the standing hasn't been decided at the district level, that's something that is a threshold issue that would be handled typically by the ALJ at a preliminary hearing. But leading up to that, in this 2-month period, you're kind of figuring out, okay, what do I need to prove if I'm the applicant? What are my elements? What's my burden of proof? What evidence do I have for all of that? Who am I going to use to testify about these things? Who's going to be my expert? Who's going to be my lay witness? And from the district side, really from the district applicant and protestant side, you're all trying to figure out, what do I need to prove? What's the other person going to say? How do I need to gather all of my evidence and get ready? And then you'll have the preliminary hearing, and standing may be addressed at that hearing or at a later hearing. And you'll kind of talk about logistically about, any limits on discovery that's going to happen. When you're preparing for the preliminary hearing, you'll hopefully notice that you don't have evidence on certain things that you need to prove. And you're like, okay, well, I need to make sure that I get that in discovery, and what type of discovery will I need to conduct to get that evidence. And so then at the preliminary hearing, you might take up standing, you might not. Typically, you talk to the judge about, logistics of scheduling the merits hearing, what limitations should be placed on discovery, if any, and then when you're going to schedule that.
So, Jim, you're on your way to SOA without your board of directors. That relationship has changed a little bit in as much as you're now a party. At your district, you always participate actively as a party in those SOA proceedings, and you've disengaged with your board that will sit as the ultimate decision maker once SOA has made its recommendation. So you're in charge of your case. If Stacy's working for you, is your lawyer, she's working for you, and Bill's working for you if he's the expert. How do you manage that, knowing what you know going into it and having a little bit of time to get organized? How are you working with your attorney and your experts?
So there's kind of a couple of tracks that go on, during those initial months. If we do think that there's going to be discovery on my end, and within the district staff, we start trying to pull together anything that we think might be sought through discovery, just so we have it prepared and ready. Similarly, like Stacy noted, you're working with the experts to try and figure out what testimony we need, what evidence we're likely to need. But really, the biggest part is, like I say, from the district staff perspective, you're doing double duty of preparing like a witness, but also trying to manage the logistics of getting the case, getting everything into SOA, getting the contract signed and finalized, and then, finishing up your preparation from there. And then, of course, as you mentioned, being a separate party from the board, you may also have to be tracking down legal representation for either for yourself or for your board throughout that process. So there's during those initial months, there's a lot of things that have to kind of be taken care of and sorted out at the district level.
So, Bill, you have quite a bit of experience working with general managers and through that SOA process. What would you add to Jim's observations? What are the things that you're typically doing or enhancing what you've already done in order to prepare to be deposed in a deposition, to work with the lawyers at some point on pre-filed testimony? What are the types of things that you're doing?
Yeah, those are the key elements are expert reports, depositions, anything related to getting prepared. The pre-filed testimony is useful to sort of streamline the process, but it does have a big disadvantage from a technical perspective because you're not always able to convey the technical analysis appropriately. And so I always try and push for some sort of technical report or expert report that can actually lay out the analysis or the answers to the questions in a more concise way that sometimes pre-filed testimony can't capture.
Yeah, and let's talk about that work product for just a little bit. I think it'd be helpful for the people in the room to know that we've left the groundwater district and the board that knows something about the aquifer. And we've usually gone to Austin. There's some discretion on where we are, but we're with Austin-based administrative law judges, many of whom aren't living groundwater. And what are your thoughts about how you're conveying information about an aquifer that they may not have heard of? And these permitting criteria that Stacy and our panelists have talked about, how do you, what's going through your head about how you're educating somebody that doesn't have that experience with groundwater?
And that's where the pre-filed testimony comes in, is that there's a lot of opportunity in the pre-filed testimony to do the basic educational part of it, but it's in writing. And that you lose a little bit, unless if you had live direct examination, you can actually get into teaching mode better. So there's limitations to all this. And that's where I was saying the technical report or expert report can dive into the specifics that are more, the audience is there for more for the other side's experts, rather than the judge. The judge needs to have some understanding or basics, and that's where the pre-filed testimony can actually, you take some time and actually do some educating in that document.
Right, so let's segue to the hearing itself. We're all prepared. The hearing isn't an event on a day. It is an event over months. And so Stacy, if you could talk through a little bit just conceptually on what the event looks like. For the room, if you could talk a little bit about like what it means when we talk about discovery. We've mentioned pre-filed testimony, like what that is, and kind of sequencing wise, what are the various steps and generally how long it takes.
Sure. So between the preliminary hearing and the merits hearing, which is basically a trial, they don't call it a trial, but it is a trial. It's basically a bench trial with, a non-jury trial, which we call in the litigation world a bench trial with a judge. But it has, other than the pre-filed testimony, which is submitted in advance, it has all the components of a regular trial that you would see on TV, just without the jury being there. So you have cross-examination of witnesses, you have redirect of witnesses, but the discovery period happens before the trial or the merits hearing. And that can involve written discovery, oral depositions, requests for admissions, requests for production, which is documents. And I think discovery can be very effective and cost efficient if you know up front what you need to prove, what evidence you currently have to prove it, and what you need in discovery. And then you send very targeted discovery for what you need, not just like, I'm going to send discovery for the sake of sending discovery, because that can get really expensive. But discovery is the mechanism by which you get the additional evidence that you need. You're going to want to depose all the experts if you can. Sometimes there are cost limitations, but I'm going to want to know what Dr. Hutchinson is going to say about, if he's representing the district or the protestant and I'm the applicant, and I'm going to want to be able to question him about his expert report, or if it's provided in advance. And it just gives you an opportunity to prepare your evidence, hear the other people's evidence, and sort of prepare your rebuttal evidence to that, all in anticipation of the event, which then, involves calling witnesses and then being subject to cross-examination. And you have expert witnesses who are technical witnesses that are going to talk about science, and then you have lay witnesses or maybe, client representatives who are going to talk about factual issues. And going back to, sort of telling your story and what's persuasive to the judge, I think visuals are hugely beneficial for people who are visual learners, but also for very technical things. Showing exhibits about, the design of the well field, for example, with respect to, existing wells nearby when you're talking about impacts. That visual representation of that can be hugely beneficial for everyone involved. So I think, you've got this written stuff and the reports, but you also need to translate that. We heard talk about data, and we saw that slideshow where it took the raw data and then it iterated it into something that made sense. That's the same thing you're doing with your evidence. And you've got to streamline it and make sure that you're telling your story and that people can understand it.
And let's talk about that. And Stacey, I appreciate that you've likened the process to what folks have seen on TV. And Jim and Bill are going to comment on that a little bit because they get to enjoy being on a hot seat. They're the ones that Stacey calls to the stand, either because she's their witnesses or because she's going to cross-examine them. So Jim and Bill, if you could comment on what it's like being in the hot seat, and we're not talking that you're prepared. So what are your thoughts about you're stepping up and you're trying to convince one or two judges of what's right or wrong? And Jim, let me start with you. You've been on the hot seat quite a few times.
Playing dodgeball blindfolded, that kind of comes to mind. It's one of those things, it doesn't seem to matter how well you're prepared. It's going to feel like you're not prepared, you're not ready, and all you can do is answer to the best of your abilities. I definitely feel like I gave blood every time I get done testifying because my blood pressure has dropped by about 30 points from the time I started. It's a challenge, but it's not an impossible thing. And Bill, you've done this so much more than I have. Maybe you're listening to me and going, rookie. But maybe Bill has a better perspective on that.
Well, the one thing that's unique about these SOA hearings is the number of parties. Usually you get involved in, I've been involved as an expert witness on some cases where there's just two parties. And the contested case hearings in SOA are unique because there's pre-filed testimony. And so your testimony, your live testimony, you're being attacked by 7 or 8 different parties on a cross-examination. And so it sort of is a different way than usually you can get warmed up in direct examination, explain what you did and how you did it, and essentially get into a rhythm. And all of a sudden in these contested case hearings, you're sitting there, you've got a couple of binders in front of you with your pre-filed testimony, and the hard questions start immediately. So it does present a challenge, and it's unique in comparison to some other expert witness type environments that you might find yourself in.
So we're in the heat of this battle, and we're supposed to share with the crowd how you navigate this journey. There are times during any trial where there is a eureka moment among everybody who knows what's going on. And I mean when the applicant and the protestants who are sophisticated looking at each other saying, oh my gosh. And sometimes, and we've all, many of us up here have had some experience with a judge who has said, okay, we're gonna take a break, and I want you all to step out in the hallway and talk about settlement. So I'd like, we only have a couple more minutes on this particular topic, but I'd like for you all to share your view about how once you're in the heat of battle, that doesn't necessarily mean that the parties, it doesn't mean that we're going to fight it out for years. And talk about how it can be wise to leave the door open for discussions and having a professional working relationship with your opponent. Stacy, Bill. Stacy and I we've settled a case in the heat of battle.
Only because my client agreed to pay you millions of dollars.
Because you were sucking us dry, and we got it done. It was a win-win.
Here, wait, now it's on.
Money
My
talk.
client's in the room. She's pleased.
Yeah, I mean, obviously, it's from a technical perspective, if there's some common understanding of what the potential impacts could be, how to deal with it, there's always a chance for settlement, whether it's feasible from a financial or political perspective. That's always a different question. I mean, I'm involved in attempting to settle a very big thing right now that I can't get into, but it's a process, and it can be as expensive and, mind-numbing as hearings can be. So it's just a matter of whether there's, my experience, if there's the political will to settle something, it can be settled. If there isn't, the hearing continues.
We've got just a few minutes. Let me move on to that. We'll settle it afterwards, Jim. Let's talk about this thing that we call a PFD. Everybody on this panel knows what the acronym stands for, and you'll hear it from whoever wants to go first. But I'd like to talk about what the reaction is from your clients, whether it's the groundwater district's general manager, the applicant, the protestant. When you get this recommendation, it's what, a paragraph or so, right? How long is the PFD? What is it that Blaine receives when this referral that she's asked for comes back to her? So we've got about 3 or 4 minutes to talk about the proposal for decision and how folks react to it and what remedies you have to be critical of it if you're not pleased with what the judges are recommending. I know you all have
It's
something
usually
to say.
very long. So it's like the client's like, what is the net? Tell me, did we win or lose? And it's like, I'm not sure yet. I'm only on the first paragraph. And unfortunately, they didn't lead with the conclusion. So
How many pages?
Hundreds in some cases. So it takes a while to get through it. But once you realize who won, who lost, or whether there was, a parsing of that, you win on some, you lose on others, then it goes back to the board, and the board, Blaine's going to ultimately be deciding, whether there's going to be any changes made to that. But it's like, what is this? And this is what I paid for. Tell me what it means.
Jim, your district paid for a few of those, and you've read the hundreds of pages. Observations?
It's like any other judicial ruling. So it's one of those things where you kind of wade through it, and yeah, you're definitely going through paragraph by paragraph, going, okay, it's good, it's bad, it's good, and then, ultimately you get to the conclusions and realize, or maybe you cheat and you just flip directly to the last page and start there. It's
last pages.
Pages, yeah, sorry. But ultimately, you get, it is just a recommendation from the judges. It's a very strong recommendation, but it is not necessarily the final word, and it's always going to be up to your board to look at that recommendation and figure out how they want to implement anything that's found within it, within the bounds, that are available to them. So I think that might be a good time for.
So let's talk about this. Blaine, you handed that baton over to SOA, and unlike track, the sport, they hand it back, right? And so this proposal for decision and accompanying findings of fact and conclusions of law that often are 100 pages plus or minus, they come back to you. And before we start with you, Blaine, Stacy, I'd like for you to talk about that bridge. So SOA, literally, they email it back over to the district's, probably whoever the board designated as the contact person, that's probably you, as say the lawyer for the board. Legally, what are your board's next steps?
Well, we're going to have to look at it, but eventually they are going to ultimately be scheduling the final hearing on it. And that's where they're going to be making a determination on, okay, yes, we're going to give a thumbs up to the ALJ, or we're going to give them a thumbs down, and what are we going to change? And that hearing can be continued like other hearings, like the preliminary hearing can. And then hopefully, your lawyer's giving you good advice about here are the limited circumstances in which you can change the proposal for decision, and you're starting to identify whether there are some potential areas for that to happen. Sometimes you have things that are very, that were mistakes and errors, and it's kind of uncontested and undisputed, and the parties can kind of agree, hey, we can change this word here, or that's a typo or whatever, but that's all pretty easy. But whether or not the ALJ improperly applied or interpreted the law, the rules, or decisions is really the crux of what the board is deciding.
So let's come back to Jim and Blaine, who have had some different experiences with how you're handling things before the board. And Jim, let me start with some of your more recent experiences. There's some judgment calls that your board makes about whether you want to hear from the applicant or the protestants, or whether your board even wants to hear from you. What else? In person, orally. Whether your board is going to take remarks from the parties, oral argument we call it, whether there's going to be additional written briefing, or whether you're going to allow the dozens, if not hundreds of people who care about this but who weren't parties want to show up. You sometimes are trying to figure out, are we having it at my office, or am I renting the convention center for the next stage? Literally. So thoughts on how you make those decisions and advice for the crowd?
So, in that process, we've got, obviously, one of the first things that comes up with our board is, the possibility of remand, where if you feel the question's not adequately addressed by the PFD, to send it back to the ALJs and have them reevaluate that. But once we've moved kind of through that process, and we go through the exceptions and the exceptions to the exceptions and the exceptions to the exceptions to the exceptions, and we have something that's coming close to a finished document, then that's really a question that we work through with the board with regard to what that last step is. Do they want to have another round of oral argument, or do we want to say the PFD is now closed, this is what we're working off of? And at that point in time, you can bring in public comment, but the record is closed, the file is written. It's, you need to make clear that people understand that if they are coming in to give public comment, at that point in time, it's really just, yay or boo for the judge, because nothing else is really going to make a difference at that point.
So Blaine, you can call the shots on some of these options that you have, or you can ask your board to pass a motion. Hey guys, how do you want to handle this? I don't want to get in front of you board members, because our constituents are in the room. How do you talk through that, and kind of what are your thoughts for this crowd on what's best for your constituents and ultimately making a defensible decision?
Yeah, there's a lot going on at this point, because after I had passed off the baton, or the board passed off the baton, we had to leave the stadium. And we,
the state?
The stadium, because yeah, maybe the state. But we had to leave the stadium where that hearing, I'm using the race analogy to represent the hearing that everybody else was working on. So when SOA brings that baton back to us, it's a fire hose of information that the board has to catch up on. And so, that requires the attorneys to give us the rundown on it. And so the board has a separate attorney. And so as we are looking at that, that's legal advice. We're going into executive session to discuss the fine points of that proposal for decision. Executive session, you can't do any action, so we do need to come out in open session to determine if that proposal will be remanded, if we will accept the ALJ, or if there's other decisions we will make.
So we have 6 minutes, and Leah, we're going to stay on time. And I have a question for Stacy, and it's going to segue into our takeaways. But still on this topic of how the board is vetting this. Okay, put yourself in the shoes of counsel for the board, and be clear about what you can and can't talk about in executive session briefly. But let's talk about special permit conditions, which is often the discussion, because you got 3 options: grant in its entirety, give the applicant what they asked for; deny in its entirety, don't give them anything; somewhere in between. And the somewhere in between often comes down to conditions. some that are imposed involuntarily, some involuntary. If you could comment on that, bearing in mind that we're going to move into takeaways. I know the panel has some thoughts on that, and that's an important issue.
Sure, I think, typically it's not an all or nothing and you end up getting some modification. And so it's going to involve special conditions. And I think districts need to be really careful about what special conditions they impose. Is there statutory authority for the condition that you're seeking to impose on the permit? Is there a legal basis to do it? And are you doing it in a way that is kind of ad hoc, where maybe you're unintentionally discriminating against exporters because it's a large export project? Or are you in some way holding this permit applicant or a group of permit applicants kind of solely responsible for achieving the DFC? I think there are ways to use those conditions, but you have to be careful about it and be thoughtful about it. And then in terms of executive session and deliberation, you can't deliberate extensively in executive session or really at all. I think you can go in there and get your legal advice and then come back out and have your discussion in front of the public. And it makes people feel better if you give a reason. If you're going to be changing the PFD to provide, some rationale for doing that, state that you're going to do it. And you don't have to go into detail about it, but at least let people understand that there was some reasoning behind this decision. I think later when you ultimately adjust the PFD, you'll get into the nuances and details of the changes being made. But my advice is to have some sort of discussion, and the lawyer can help give you a roadmap, not a script of what to say, but like a roadmap of the elements that will guide the discussion and the deliberation by the board in the open meeting.
So I'm going to open it up to the panel. We've had some conversations about things that we wanted the audience to leave with as they walk out of the room, back to their homes and offices today. We've got probably another 3 or 4 minutes. Y'all share your thoughts on some of the takeaways that you like to leave with this crowd.
Well, from a technical standpoint or expert witness standpoint, the basic message is write your reports, know your if you're doing a deposition and before the hearing, know that deposition's inside and out so you're able to effectively communicate what you've done in the context of the questions being asked.
I'll go next. I think it's true for whether you're the applicant, the district, or a protestant, or the general manager, arguably, and then the board, or the protestant is just be prepared. Don't underestimate your opponent. Know what you're supposed to prove. Get all your evidence in. Don't ignore weaknesses in your case. I've seen it be devastating when there's a weakness in the case and the applicant knows about it but doesn't address it, and then it can, be fatal. So prepare your rebuttal evidence and make sure you get it all on the record.
From the board perspective, the time that it would take the board, I feel that SOA is a really good alternative for a hearing, just because it removes that learning curve from the board. But what can't be forgotten is how much time it's going to take a staff, because they still are a party to that contested case. So although the board has referred the hearing to SOA, staff is in the weeds.
Thank you. I really appreciate you saying that. I'll follow on, in support of using SOA for these contested cases. It is a lengthy process. It is not a cheap process, but it is a way, especially in a highly contentious application or highly contentious, permit, to really drill in, get evidence on the record, and come to a conclusion that I think, if people may not necessarily like it, but at least it is a decision that people will understand how it was arrived at. Especially if you follow on after the PFD by having those board discussions that Stacy mentioned, and having all that, between the evidence developed by the experts, the process that goes through SOA, it's not necessarily a consensus building activity, and it's certainly not fun, but it is a way, I think, to address a lot of the uncertainty and a lot of the angst that can develop around some of these large permits.
Leah, our MC, thank you for inviting us as your final panel. It's been good being with you at the end of the conference. I hope we met the objectives and left some value with the folks in the room. Thank you.
Absolutely. And we did get a couple questions on the app. I just want to first see if there was anyone in the room that wanted to ask a question.
Thank you. What would your experience and wisdom be with respect to the interaction of board members with their precinct constituents regarding a contested case and very much more broadly, non-contested case matters of the board?
So in the contested case, the board is really put in an awkward position with your constituents because you want to respond to them, you want to answer questions, but I had to explain. I said, this is a formal legal proceeding, and I am not able to discuss this project or this case because I am the board is the final judge and the final decision maker. And so I think the term is ex parte. So that's the legal term. And you just have to apologize and say, I'm sorry, but if discussing this case could jeopardize my ability to represent my precinct in the final decision here, because I would be unable to vote. And then refer them to their general manager.
That was a great answer.
And then one other did come in, and I think it kind of goes to you, Bill, about there was a discussion early on about the hydrogeological studies, and the question was whether or not those are something that the applicant is required to perform. Does the district do that? And are those required for all permits?
That's a district specific. Whether it's the applicant is required to do it, some districts, the district does those reports, and the scope and elements of the report are very much district specific.
And let me say, I strongly encourage all my clients, whether I'm representing a groundwater district or an applicant, this is all about the science. Whether you're preparing a report or you're preparing a picture that shows what we want to do and what the aquifer is going to look like when you start pumping, we got to have an expert and we got to get prepared, whether or not the rules require it.
Thank you all so much. That was fantastic. All right, a couple final announcements. Bingo winners, folks who visited all of our fantastic exhibitors out in the hall. Kelly Cochran and DeLorean Wiley are the winners of the $100 Visa gift cards. I don't know where they are, but we'll make sure to get them to you. Find one of us and we'll do that. The photo booth is still set up if anyone wants to grab one last photo before they leave today. I just got to tell you, I so appreciate all of our sponsors, our speakers, exhibitors, and all of you who came and attended this event. Everybody really contributes to make it such a success. Thank you. We absolutely look forward to hosting you again next year around this time. And until then, safe travels.